Adjournment request, if any, from item number 1 to 7.
May I please, Your Lordship? I beg to make a mention for listing of 3 items for motion tomorrow, Your Lordship.
Let the,
Sorry?
let the mentioning be complete.
Your Lordship, I apologize.
Lordship, I beg to mention item number 1. The matter will pass off for the day, Lordship.
Why?
Lordship, Digogoi has some difficulty today, Lordship. Listing.
Vacation.
Like,
From item number 8 to 13.
May I please, Your Lordship? With the consent of the petitioner's counsel, I beg to mention item number 9, Lordship.
9.
Lordship, we have to file affidavit in opposition, Lordship, that we are filing today. May it be posted after vacations, my lord. I'm obliged, ma'am.
May I please, Your Lordship, with the consent of the other side, I beg to mention item number 11, Your Lordship. Senior Counsel D.N. Panda from Odisha is supposed to argue the matter. Your Lordship kindly fix this matter after vacation on 21st of January.
21st January.
Obliged, Your Lordship.
Any other request?
May please, Your Lordship. Lordship, I beg to mention an item for listing it as per convenience of your lordships either today or tomorrow, my lord.
Which
The
one?
unlisted matter, my lord, motion matter, my lord.
Why? What's the urgency?
Urgency is that, my lord, I am a defaulter of a loan that has been availed by me. I have committed before the recovery case is pending before the recovery officer. I have committed before the recovery officer and I have filed my representation that I want to repay my loan. Now, without communicating anything, without disposing of my representation, they have issued a sale notice. The auction has been fixed.
Challenge it before the DRT.
My lord,
DRT. Debt Recovery Tribunal.
my lord, I think the Debt Recovery Tribunal is not having us to stay the sale notice, my lord.
Everything is there. They can pass very well. They can pass the appropriate orders. Yeah. Is there?
My lord may allow my petition, my lord, but try my luck tomorrow, my lord.
Not at all. Not in these matters. Approach the DRT.
My lord, we are not
Don't
challenging it.
waste your time, sir.
My lord, we are
Waste
not,
your time. We are not going to give you any relief in this.
I have committed before the bank that I paid them.
Sir, you go before the DRT, that is the appropriate forum. And the Supreme Court has said many times, many matters. Approach the DRT or let the matter comes in the January, we'll see to it. There is no urgency.
My lord, let me try my luck tomorrow, my lord.
Please. Stop. Yes,
I'm obliged.
May I please, Lordship? Lordship, I beg to mention item number 8, my lord. My lord, the lady engaged counsel is at Vellore CMC. It's under medical treatment, my lord. The lady engaged counsel is under medical treatment. He is in Vellore, my lord.
delimitation process, we have already disposed of many of the petitions. PIL is not maintainable. Can file separate proceedings,
My lord.
not as a PIL.
My lord, he will satisfy the court, my lord, next week, my lord. After vacation, my lord.
Look at this. PIL petition is filed by the petitioner challenging the delimitation process in respect of one of the district of the state of Assam. Prima facie, we are of the view that the grievance raised by the petitioner to this PIL is his individual grievance, and therefore the PIL cannot be maintained for redressal of. The PIL cannot be maintained by a person for redressing his personal grievance. With that as a personal grievance. Full stop. Para. And it consent of Mr. So-and-so has submitted that Mr. Consent for the petitioner is not attending the court on account of medical emergency.
Medical emergency, my lord.
Medical emergency. Is this matter after due vacation?
May I please, Your Lordship? I beg to make a mention for listing of 3 matters for motion tomorrow, Your Lordship. There is an urgency.
What's the urgency?
Your Lordship, these are electricity matters. A huge sum has been wrongly levied as deviation charges in the electricity bill of around 20 crores, Your Lordship.
If the demand is not stayed, there is a possibility that the power line will be cut to the industrial units.
So you are challenging action of which authority?
APDCL, Your Lordship.
So how it is?
Your Lordship, we are challenging the wires and validity of the AERC DSM regulation of 2019 as well, Your Lordship.
Not in this manner, January.
Your Lordship, if the power line is disrupted, Your Lordship, there will be an.
We'll restore it on the January if you have any prime officer. January.
Orders, item 2.
May I please, Lordship? In this
Respect
case,
of,
my lord,
respondents number 6, A, B, and C. The notices are not. been
service is waiting, my lord. And Lordship, I would like to notice before this court that with regard of the similar situation and regarding challenging of tax relinquishment deed, title should also file, my lord. And here, my lord, respondent number 6 also their legal hair appeared and filed WS. So my lord, humble submission as per the defendant number 1 and 2, that is here, my lord, made party 5 and 6. They entered their appearance and filed WS, my lord. And in title suit, Lordship, challenge made regarding the relinquishment, tax relinquishment.
So here the notices are not required to be served upon them.
But I would like to, my lord, submit, my lord, I would like to withdraw and subject to outcome of the title suit, madam.
This writ appeal,
Lordship,
he wants to withdraw this.
withdraw subject to outcome of the title suit.
Subject to, what do you mean by how it is subject to outcome of?
My lord, here also, my lord, they claim the share of compensation regarding the riot. And on the basis of the tax relinquishment deed. But because respondent number 7 made, my lord, submitted some tax relinquishment deed. That has been challenged in the title suit. So civil court will decide whether this relinquishment deed is genuine or fact. And on the basis of this relinquishment deed, the share of compensation so far LA case is concerned is to be given. And notice already served to the other side, and 1 and 2 already filed affidavit, WS, my lord. And in title suit also, my lord, that this compensation of acquired land in pursuance to the LA case number 11/2014-12 also in prior portion clearly mentioned. And here also, my lord, ratio is
Who
the
has
same.
filed this title to?
Title suit, this appellant, my lord,
Appellant has filed.
lordship.
And the concept of the writ appellant has submitted that since the title suit preferred on behalf of the petitioner is pending consideration before the assistant session judge,
Kamrup Amingao,
Mingao, he does not want to press this writ appeal. Dismiss does not press it.
May I please? My lord, I'm appearing for respondent number 7 in this writ appeal. And already I have submitted my affidavit in reply.
When he is withdrawing, what is the problem? Do you have any objection in withdrawing that?
Yes, my lord, I have objection because my lord, while passing the impugned judgment and order against which this appeal has been preferred, I have been given the liberty. I being the writ petitioner, I was given the liberty to approach the Honorable Civil Court under section 18 of the Acquisition Land Act for a reference. But because of the pendency of this appeal and because of the stay order granted by this honorable court, I could not prefer that application.
So now,
And now the same appellant, my lord, the same appellant has preferred a title suit as stated by my learned friend. So I have not yet received any copy of the notice or any summon from the civil court. But as because the appeal is pending, so I have the objection definitely, my lord.
so when the appeal is withdrawing, he is withdrawing the appeal, what is your objection now? Whatever the
No,
problem
yes,
you are
because
facing
uh,
on account
no.
of this, now he is not
the
pressing this.
condition given by the other side is that the subject to the title suit, because already they have filed the title suit without taking leave of this honorable court. My lord.
This order certainly,
My lord.
it will be governed by the, whatever the order passed by the trial court.
That's all.
Highly obliged.
Item 3.
Please, Lordship. Lordship, as per office noted dated 16/12/24, Lordship, service is not completed upon respondent number 6, Lordship.
Respondent number 6, yes, you are appearing for
1, 3, 4, and 5, my lords.
1, 3, 4. Take fresh steps. Yeah, notice upon the respondent number 6, has not been served. Things long. Learned concept of the applicant is directed to take steps for service of notice upon. So what's wrong in this order?
Lordship, order was passed for
It was
temporary
in your
correction.
favor. The
Lordship.
order is in your favor.
But Lordship, FDCL, Lordship, charging fixed amount, Lordship, monthly in 5,050 rupees.
Obviously, they'll charge the fixed amount since the temporary connection is granted.
Lordship, applicant faces financial hardship, Lordship.
Financial hardship, so when the dispute is going on, how can we ask the electricity authority to grant you a permanent connection? The court has already ordered that restore this electricity supply, they'll say restore it. Why you have filed this appeal?
That's why I filed.
This order is in your favor.
Yes, Lordship, but now I want to permanent connection.
And in the writ petition, you have simply prayed that direct them to provide me connection, not permanent or temporary. There is no prayer of this effect.
Yes, Lordship.
So the learned single judge has already granted this prayer.
But Lordship, I have filed a review petition for permanent connection, Lordship.
Review petition,
Yes, Lordship.
you may file,
Which was dismissed, Lord.
you have already filed or you want to file?
Review petition already filed, Lordship.
You have already filed.
Filed. It was
Then
dismissed, Lordship.
what happened in that?
Was dismissed, my lord. Page 105, my lord, is the order.
Review petition.
Yes,
Yes,
my lord. The
Lordship.
review was dismissed, my lords.
Can't be the reason that we should interfere with the learned single judge order. You have to pay more. You have to pay more if you want electricity connection. And certainly when the title suit is pending between the parties,
Yes.
you can't be provided this permanent connection.
Lordship can pass over matter for timing, Lordship.
For the time being,
Yes, Lordship.
we'll take it up today only.
Yes, Lordship.
For admission, item 4.
See that compensation, whatever the.
No, madam. No.
Why? Or you are not, they offered and you have refused to take the compensation.
No, so for this, there are two acquisition, my lord. So for the acquisition for the purpose of passage is concerned, that has been offered that we have not received, but that is not the subject matter of this writ petition. The subsequent acquisition, my lord, which is for the purpose of accommodation of the AIMS officials, that we are challenging, and for that no compensation has been offered, nor we have accepted. No question of.
Compensation is already there, this, compensation has not been offered.
No, my lord. And so this acquisition, my lord, went ahead without our any intimation. It went ahead behind our back. Subsequently, when we learned, my lord, requisition part we came to learn, immediately we protested. We objected way back in 2018. Our objection was never considered, nor we were intimated, my lord. My lord.
That's altogether different thing. We are once when they invoked the provisions of 1964 in the year 2018. Why not challenge the validity of that 1964 act at that time?
My lord, we have said that so far this requisition matter is concerned, we protested. Now,
Protested is another thing. Now you are.
but we were not intimated that subsequently it was acquired. So unless it is acquired, my lord, there is no question of raising objection. And now, my lord, the
Even though
law is set.
they have invoked the provisions of 1964 at the time of requisition of the land also. So there was occasion for
No,
you to
my
challenge
lord,
the validity
requisition
of
and
this act at that time also.
Requisition and acquisition are two different parts, my lord.
But,
The government may require, but may not acquire subsequently. So unless it is acquired, my lord, unless it is acquired by the government, there is no opportunity for us to challenge the validity of the law. And my lord, now what has happened after the 2013 Act coming into force enacted by the Parliament, this Act itself, the entire Act has become repugnant. Unless it is revalidated by a fresh action of the Honorable President, it cannot be enforced, my lord. Because there are many things which has not been taken into account.
And now
So,
they have issued a notice that the compensation will be paid in accordance with the Right of Fair Compensation Act 2013.
so for payment of compensation, the amount is concerned, my lord, it may be under the 2013 Act offered by the government. But what is the social impact? Whether that has been considered? No. And this is a very vital part of the 2013 Act. Now, what the government is doing, my lord, the state government, it is only for the purpose of calculation, is taking recourse to 2013 Act, and the rest of the provisions of 2013 Acts have been put in the back burner, my lord. Those are not considered. And we are not opposed to any development, my lord. What has happened under the 2013 Act, we are given an opportunity to raise objection because the government has got the entire land which is available with it. It is sufficient for the accommodation. Now the government has come out of the AIMS area and wants to make the accommodation outside the walled area.
That is for them, sir. Where to
So these
accommodate them and where not to accommodate, we are not concerned with that.
But in
That is
2013 Act,
purely within the domain of the administrative authorities. So far as regarding this repugnancy part of it,
but my lord, in the 2013 Act,
pursuant to the time given by this court on 20th of November 2024, an additional affidavit is filed on behalf of the appellant. pointing out the repugnancy between the Land Requisition and Acquisition, the Assam Land Requisition and Acquisition Act 1964 and the right to fair compensation and transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. Copy you have supplied them?
Till now, no lordship.
The copy of the said additional affidavit preferred on behalf of the petitioner to be supplied to learned advocate general. The appearing on behalf of all the respondents,
Yes, Lord.
all the respondents.
Except the aims, lordship. I'm just.
You are appearing for aims on behalf of respondents number so and so, so and so.
Except
So and
three,
so
I
is
appear
appearing
on.
on behalf of the respondent number so and so. And the advocate general may file counter to the other petition as well as the additional affidavit filed on behalf of the petitioners. Place this petition after in the month of February.
Lordship.
Highly obliged. My lord, we have made prayer for status quo. My lord,
Sir,
they,
at the most, you are entitled for compensation that we will consider.
my lord, kindly consider since 2018 till 2024, my lord.
For admission, February month of, yes.
Status quo in regard to the suit land, my lord, was disputed. My lord, it is only accommodation. We are not opposing to the construction of the Ames building, my lord.
We will pass an order, required so. Yes,
Obliged.
Item 6.
since they have already taken position from you. That you have, specifically.
Only on the last month, my lord.
In October.
In October.
2024.
Yes.
457.
Immediately before filing, my lord, one day before. My lord, but
The fact remains that they have already taken position of the.
but the entire building has been erected, my lord. So far, this accommodation part, which is outside the walled campus of the Ames, my lord.
Again, we are referring, sir, we'll consider that, but prima facie, we are of the view that where to construct these residential quarters and so and so on. In that, that is within the domain of the administrative authority, whether they construct it in the Ames campus or outside it, that is for them to decide. Yes. 4 and 5, both are same.
Well,
Item number 6.
My pleasure, lordships. My pleasure, lordships. Lordships, here I am before your lordships aggrieved by the order dated 28 of 11/2024, passed by the Honorable Central Administrative Tribunal. Lordship, if I may just give a brief background of the case for a minute, lordship. Lordship, the petitioner herein is a 1992 batch IFS officer. Upon completion of 30 years, he was eligible for promotion to the rank of Principal Chief Conservator of Forest. Accordingly, lordship, on 29/8/2023, a joint cadre authority recommended for his pro forma promotion as well as on deputation to the rank of Principal Chief Conservator of Forest. Subsequently, lordship, the state screening committee dropped his name and no reasons was assigned as to why that promotion should not be granted in the month of December 2023. Aggrieved by that, lordship, we approached the Honorable Administrative Tribunal in 08/33 of 24. In that, the Honorable Tribunal was pleased to direct the authorities to consider the representation and pass an order as regards my promotion. Lordship, that was not done within the time limit prescribed and we preferred in contempt. Lordship, during the pendency of that contempt, the said speaking order that was directed to was not passed. In the meantime, lordship, on 26th of November 2024, that is the improved notification at page 113. Lordship, my junior was promoted and admittedly junior officer of 1993 batch. Lordship, aggrieved by that, we came up before the Honorable Tribunal. Lordship, the matter was filed on 27th of November morning prior to 10:30. A mention was made, matter was taken up at 12:30. Lordship, however, unfortunately, due to fault on the registry of not forwarding the soft copy, matter stood adjourned. The matter was taken up on the next day. Taking advantage of this error on the part of the registry, the authorities allowed the private respondent to join in the evening hours of 27th of November while the matter was sub judice. Be that as it may, Lordship, on 28th, the matter was taken up. Lordship, our pleaded case was that, Lordship, there is no vigilance report against us. I am not under suspension, and there was a memorandum issued against me on 28/5/2024. Lordship, the operation of that memorandum was stayed by 26 June order. Now, Lordship, after that, the operation of that
So
memorandum,
you want order on merits, which on the issues which you have raised before the tribunal and that is under consideration with the tribunal.
Lordship, now the difficulties with the, as regards the prior, Lordship, as regards the order which has been passed by the Honorable Tribunal, Lordship, none of the submissions of the applicant has been recorded. The fact that the very,
Interim order.
Lordship, the fact that the memorandum, Lordship, the Honorable Tribunal relied on the fact that disciplinary proceedings are pending. But the Honorable Tribunal ignored the fact that the operation of that memorandum has already been stayed by the same very tribunal.
You can very well point it out at that.
And Lordship, another thing is, Lordship, the Honorable Tribunal went with the merits of the other case, wherein that memorandum is under challenge. Honorable Tribunal went to the merits and said that the list of witnesses has been furnished subsequently. But then again, the Honorable Tribunal ignored the fact that list of witnesses which has been supplied is nil.
Ultimately, it's an interim order.
Interim order. And Lordship,
Wherein the tribunal has taken care of. Meanwhile, any promotional orders so issued that involves the applicant per se will be subject to outcome of the OA.
Lordship, that again is a tricky part because my promotional orders have been made subject to outcome. Involving the applicant. That,
Any promotional order, not
Lordship.
your, any promotional
Lordship.
order in respect of any person
Lordship, that,
in which you were also considered and others were also considered and one of, ultimately one was promoted, that is subject to the petition.
Lordship, that observation, if your Lordship,
Where is the requirement of that is more than clear.
because Lordship,
Any promotional order in respect of, not specifically by, in relation to you or any other person, any promotional order.
Lordship. Now, Lordship, that's subject to outcome because if tomorrow, Lordship, someone is promoted, then again I will have to file an OA giving a clarification of this interim. If only that your Lordship may clarify, then
That's if you are not clarified, that's.
Lordship,
it's obligatory
I
upon the tribunal
I
to
fully vote on to
clarify
that.
each and everything and to your satisfaction.
No, Lordship, I fully
We
vote
are
on to
more
that.
than clear that all the, whatever the proceedings of promotion that are subject to the OA, that is, and even though if this order is not passed, then also it would remain subject to the OA,
Lordship, but
subject to the final. This is an innocuous order and nothing else. Once the court has admitted it and issued notices, certainly whatever the final order, the promotional proceedings or whatever the proceedings for promotion, they would be subject to this. It is an innocuous order, nothing else.
only if it is, if that observation can be given, that might,
Then no.
only that much, Lordship. I cannot pray for anything more than. Because,
No further clarification is required.
Lordship, because involving the applicant, Lordship, if tomorrow, Lordship, another person is promoted, then whether
Another
this order,
person has already been promoted
Lordship, in the meantime,
and his promotion would remain subject to the final decision of the OA.
Lordship,
That is there.
Lordship, this any promotional thing, Lordship,
That is more than clear. At least we don't have any confusion in our mind. That is more than clear.
with that observation, your Lordship may, because only that
This
one, I understand,
observation
Lordship,
is that
that,
this petition, petitioner, being agreed with the order dated 18/11/2024, passed by the Central Administrative Tribunal, Guwahati. The petitioner has approached the CAT raising a grievance that the respondents are not promoted, respondents have illegally refused to promote him from the post of
Lordship, additional principal chief conservator of forest to principal chief conservator of forest in level 60.
additional chief conservator of forest to
Principal,
principal chief conservator of forest, and instead has promoted to respondent number
Six, Lordship.
respondent number 6, though he is junior to him, would stop. The tribunal, while admitting the OA preferred on behalf of the applicant, has fixed the matter on 16/1/2025, granting granting time to the counsel for the respondents to file their written statement and liberty to the petitioner to file rejoinder if to file rejoinder to it if desired so. Tribunal has also observed that any promotional order so issued involve the applicant per se will subject to the outcome of this OA. And it counsel for the petitioner has submitted that the tribunal has not made the promotion of the respondent number 6 subject to the outcome of the OA. We are of the view that the observation of the tribunal to the effect that any promotional order so issued that involve the applicant per se will be subject to the outcome of this OA is very clear, which means that the promotional, the proceedings of promotion undertaken by the respondent department would remain subject to the outcome of the OA preferred on behalf of the petitioner. Hence, no interference is called for. Notification takes place.
Obliged, sir.
And motion is placed.
Item 7.
Yes,
My lord, regarding this is against the learned tribunal order dated 11/12/2020, whereby the interim prayer was rejected for recovery of special data amounts. My lord, in this case, earlier this applicant has approached the learned tribunal in OA number 156 of 2018, 42 of page.
these
Oh.
28 petitioners,
Yes, the same petitioner has approached this tribunal, and tribunal has said that recovery should not be without issuing any notice. Then the respondent herein approached this honorable High Court
and up to Supreme Court.
and up to Supreme Court last order. It has been page 84. Delay condone.
Yes,
Since the petitioner sought to effect recovery from various category of employees, many of whom by now retired from them, and that too without issuing any so-called notice, we do not find any irreparable impugnment passed by the High Court of Guwahati in setting as a recovery order in action and civil cause. State be accordingly dismissed. Setting aside. My lord, thereafter, they have issued a speaking order. Actually, this learned tribunal passed
what
the
is the
order.
order of the High Court?
My lordship,
What was the order of the High Court?
High Court order is 62, page 62.
Paragraph number 12, read.
What is reason High Court? Which set aside action of the recovery unsustainable,
Paragraph
however,
number 12 of the judgment, order of the High Court,
page
82.
82. Is this on 79? Start from this 18,
Come to para number 9.
para number 9.
This para 12.
For the reason,
Considering the peculiar facts and circumstances of the case. Page 82.
yes, yes. Considering the period, we do not find error in the pathway. And so far, a group C employer Consortium has taken refuge to law laid down by Honorable Court in the Fik Masik. Clearly, case of group C employer would not be covered within the four corners of law laid down of the same case. As so far, group A, B concerns so-called notice and opportunity hearing according to principle and as every investor required to be given. That's all.
You have group B employee?
We are at the time when the SJ was granted, we are group C employee.
Now you are group B employee?
Now we are group B employee.
At that time, you were not group C employee. At that time also you were group.
No. Minor, that time we are group C employee. And so-called notice was not issued. Lordship, kindly see, two speaking order was issued.
Sir, show cause notice. Now the show cause notice has issued.
Not directly speaking order was issued.
Where is that?
One speaking order was issued on the page 86. That is 15/12/2023. Direct speaking order was here issued and copy has been served to the all of the applicant of the, this is 88. Total 85 employees. Here, one interesting fact that some of the employee has been left out. Only some selected employee, like my page 88, 1, 3, 4, 6, 9, 10, 11, 12, 14, 15, 17, 18, 20, 21, 22, 23. Those the speaking order issued only for them. Then again, speaking order was issued on the same subject, page 93, Lordship, kindly see. Same speaking order was issued. Two speaking order was issued. They have not issued any so-called notice. Directly speaking order issued to recover the amount. At that relevant term, where group C employee, this speaking order issued to the carpenter also, my lord.
Come to impugn this page number 150, impugn order of the cabinet. Page number 150, para 8.
Unless for the instruction dated 600 subject matter submitted, all these OA are 1 to 28 group B official from the date of trial.
Page 150, para 8.
Yes, I am reading, man.
Per contra learned.
That has not been submitted. The
The instructions so and so on the subject matter.
Group
And
B.
submitted that all the applicants are classified as 1 to 28 group B officials from the date of withdrawal of special duty allowance. And as per the directions given by the Honorable Guwahati High Court, the show cause notice was issued.
No, we have not had any so-called notice. Instruction.
Show cause notice.
Lordship, this is the first stage, Lordship, but this order shows that the instruction is given, the notice was issued, Lordship.
In that.
Yeah, that was not provided to us, my order. Only simple instruction are provided before the learning tribunal.
Issued. That instruction I don't have, but the order reflects that it was issued.
Copy of the instruction was
Where is your government in this OA? that no notice has been issued and directly this order has been passed. This argument was not raised before the OA.
Yes,
This argument was not raised before.
raised lordship. First it was come. 2/12 to 2024. Director of Agriculture to seek instruction in this regard. Relief came. Lordship page 149. Then again it was listed on 11/12/2024.
Where is your government in the petition? That whatever the order dated 21/8/2024 is passed, that was passed without issuing any notice to you. Where is that?
Directly speaking order was issued, my lord.
Where is the government?
And they themselves had paid the after full satisfaction. Lordship page 15.
Sir, your whole case before the tribunal was that in view of the Supreme Court judgment, now they can't issue this order.
Yes, I know.
This is what
Yeah.
your submission. It was not your case that before issuance of this, whatever the order, they have not granted you opportunity of hearing. This is not your case.
So
Before the tribunal itself. You are arguing here, you have not even raised this point before the tribunal.
and I another similarly situated case, the tribunal has granted stay.
Whatever it may be, you just first satisfy us.
We have quoted the judgment of the Honorable Supreme Court.
What relief you are seeking here? What relief you are seeking here in this petition?
To grant in time order, not to recover the SDM until disposal of the OA.
Come to your prayer.
Pending in time order by extension not to recover any amount petition.
Where is that?
Page 35.
35. What is your main prayer in the petition? 34. Page 34.
Not be issued to restore steady impugn speaking order come recovery order. That stay order of the impugn.
Under the facts and circumstances narrated above, it is therefore most facilitate that your lordship may please to admit this petition, call for
For
the
record.
record, issue rule calling upon the respondent to show cause why a writ order or direction should not be issued to the respondent to stay the impugned speaking order.
Order come.
Where is the challenge to the OA order, this order passed by the tribunal?
Yes. Interim order.
Where is that challenge?
Oh, no. That order inadvertently did.
You have, basically you have filed this petition against this order, interim
Yes,
order.
fine.
Why you have not even challenged that order?
Inadvertently it has been.
Inadvertently, then we are going, we have to go by the pleadings only.
Lordship, time may be to amend the petition.
This writ petition is filed by the petitioner, essentially being agreed with the order dated 11/12/2024, passed in the Central Administrative Tribunal in survey number 269 of 24. Whereby the tribunal by issuing notices to the respondents has not passed any interim order as paid by the petitioners. Full stop. It is noticed that in the writ petition, the petitioner has not challenged the order, has not made a prayer for interfering with the order dated 11/12/2024, passed by the tribunal. Learned counsel for the petitioner has prayed that appropriate time, some time may be granted to challenge to make necessary amendment in the prayer clause of the writ petition. Time paid for is granted just after due vacation.
And after vacation, madam, date may be given, madam.
Then a due vacation.
22nd.
Before Bihu. Otherwise, they will recover the entire amount, madam.
You can't recover the entire amount. Installments में लेंगे.
Yes, fine. So before Bihu, if possible.
Before you.
Yes. 8 June.
Right.
Item 10.
Lordship, in the main case, Lordship notice has been issued, but what happened in the meantime, they are pursuing the contempt, that necessitated the
Yes,
filing of this IA, Lordship.
you are pursuing contempt.
Yes, my lord, file is not with me, he is in the another court, so it may be left over.
Who is in the another court?
In court number 15, he is
Who?
busy there.
Leading
Gaurav Sharma.
Password for the time being?
Left.
Password for the time being?
timing, that's all for you.
All right.
Timing meter 3.
Thank you, Your Lordship. My lord. In this case, my lord, I have approached before the learned single judge, praying for my lord, permanent connection of the electricity, my lord.
Read your,
Lordship.
in the writ petition.
Yes, Lordship. Lordship, may kindly see page 46, my lord. First one, my lord, in the premises exception, it is therefore prayed that your lordship would be graciously pleased to admit this petition, call for the record, issue a rule calling upon the respondent to show cause as to why the writ in the nature of statutory mandamus or any other appropriate writ order direction shall not be issued declaring the impugn action of the respondent is illegal for not providing electricity connection in the name of the petitioner, and further direct the respondent, more particularly respondent number 3 to 5, to accept and process his application form already submitted annexure 7 without insisting for no objection from respondent number 6 and his van, and after hearing of the parties and perusal of the records, make the rule absolute and or pass so and so manner. B, my lord, here my interim prayer was there. In the interim, your lordship may direct the provisional measure to supply
There is
electricity.
that permanent connection. Where for permanent connection in the writ petition.
Yes, my lord.
What is that?
This was because, my lord, I have submitted annexure 7 of the repetition, my lord, for my lord, permanent connection. It was permanent connection. And as an interim measure, my lord, I prayed for my lord provisional connection, my lord. But the learned single judge has, my lord,
Rightly so.
my lord.
Rightly so.
Thereafter, my
When the
lord,
title suit or dispute between ownership regarding ownership is pending consideration, how can we grant you permanent connection?
my lord,
Under which law?
learned single judge was first ordered in the light of the Honorable Supreme Court, my lord. And in the Supreme Court order, there is no mention about, my lord, temporary connection.
Ultimately, it's a discretionary power.
Yes, my lord.
Equitable relief has been granted. We don't find any illegality.
My lord, thereafter, I prepared the review petition that was also dismissed.
That has also been dismissed.
Learned single judge. My lord, I am in hardship because, my lord, in every month, my lord, I have to pay
So
5,050 rupees.
if you want this luxury of electricity, if you want this electricity connection, you have to pay the money.
But, my lord, this is extra burden for me, man.
Extra burden, then or get the matter settled between you and your the siblings or whatever it may be.
So far, my lord, possession of my premises, they have not disputed.
Once the civil dispute is there, we can't pass an order which may create some equity in your favor. This can't be done.
My lord, so far, my lord, Supreme Court order is concerned, my lord, nowhere mentioned about the permanent connection, my lord, temporary connection.
That's all.
I have submitted also representation before the authority, my lord, that was also not considered.
So, withdraw it and pursue that representation.
So lordship may kindly observe.
Yeah, learning concept of that. As per the office report, the notice in the IA, notice issued in the IA number so and so. The matter comes upon for consideration of the IA number so and so, referred on behalf of the applicant with the prayer to condone the delay of 87 days in filing the connected writ appeal. Full stop. The connected writ appeal is filed by the applicant being agreed with the order passed by the learned single judge, wherein the learned single judge, while disposing the writ petition filed on behalf of the applicant, has directed the Assam Power Distribution Company Limited to provide temporary electricity connection to the applicant in his residential house. Would stop. The learned single judge, while issuing such direction, the learned single judge has taken into consideration the fact that a dispute regarding the title of the residence in which the petitioner is residing is pending consideration. Before the civil court. And before the civil court, however, the electricity, which is a basic amenity cannot be deprived of to any person as ruled by the Honorable Supreme Court in delete in bracket dead through allowance versus Satish and others reported in 2022 0 Supreme in bracket SC 1485. The petitioner, the applicant dissatisfied with the order passed by the learned single judge has filed a review petition. However, the learned review petition with the prayer that the APDCL be directed to provide permanent connection instead of temporary electricity connection. Which was given to the, given to the petitioner pursuant to the direction issued by the learned single judge in the writ petition. The learned single judge has dismissed the said petition, said review petition on 19/8/2024, while observing that since the title suit between the parties is pending consideration, this court has rightly, the court has rightly directed the APDCL to grant temporary connection to the applicant. I mean, applicant, full stop. As per the office report, the notice of the application issued to the respondent number 6 has not been served till date. Be that as it may, learned counsel of the applicant has submitted that he has already moved and representation before the APDCL for redressal of his grievances. Therefore, he may be allowed to withdraw this IA as well as the connected writ appeal with the direction to the APDCL to consider his to consider the representation of the applicant sympathetically and expeditiously. Stop. In view of the submission made by the learned counsel for the applicant, this writ appeal, the IA, this IA number so and so and the connected writ appeals number so and so are disposed of if the representation filed by disposed of with the direction to the APDCL that if the representation so filed by the applicant has not been decided till it is expected that the concerned authorities of the APDCL shall consider and decide the same expeditiously in strictly in accordance with law.
Supplementary list for orders, item 14.
Right, please, Lord.
Yes,
The order has been complied with, my lord. The reason order has been furnished a copy to my learned friend.
when this order was passed.
Oh, yesterday, my lord, because there is a delay. If I may point out, my lord, when the order was passed in the BIL, my lord, we were not even aware of such proceedings being initiated because we were not served a copy. And our names were not reflected in the cause list, my lord. So we were never aware of the order. As I had impressed.
Yes,
My lord, we do not have any objection, my lord. If the, my lord, disposal order of the representation, my lord, if anything, my lord, contrary, the petitioner may be
always
liberty to.
this contempt petition is filed by the appellant, by the petitioner complaining that the order passed by this court in PIL number 67 of 2023 has not been complied with. This court, while order dated 18/10/2023 has disposed of the PIL number 67 of 2023 has granted liberty to the petitioner to file fresh representation before the respondents for ventilating the petitioner hai or petitioners hai?
Petitioners.
Petitioners hai,
Peti-
more than one.
Yes.
इसमें इसको कहते हैं petitioners for ventilating their grievances with the further observation that the said representation be decided and communicated to the petitioner within a period of 2 months from the date of submission of copy of this order. From Learned counsel for the applicant has submitted that. As a matter of fact, the order passed by this court on 18/10/2023 has never been communicated to the concerned authorities, either on behalf of the petitioner or the concept appearing for the ASEB. However, now the representation filed by the petitioner has already been decided on 18/12/2024 by a reason and speaking order. In view of the fact that the representation filed by the petitioner has already been decided, we don't find any reason to continue with this contempt proceedings, with this contempt petition. The same is therefore disposed of, notices discharged. However, if the petitioner is aggrieved, the petitioners are aggrieved by the order passed by the tribunal, by the Assam Power Distribution Company Limited on their representation, they are always free to take appropriate proceedings against it in accordance with law.
I'm deeply.
Obliged.
The
I-
observation, consideration, disposal.
Item 15.
आ गया। Victim?
May please, your lordship. My lord, the learned single judge order at page 160, my lord. Here in this case, my lord, the moot question involved in this case is that when a contractor participates as a startup in the bid proceeding, whether separate contractor's registration is required or not. That is the moot question before this honorable court. And as per clause 3E of the NIT, that exemption has been given. Kindly see that part, my lord, at page 45. Page 45. Lordship got it.
Yeah.
3(2)E. All startup, whether MSME or otherwise, failing within the definition of as per Gazette notification, so and so, or as amended from
A is at page 44.
page 44, page 45, page 45,
Page 45 is 3(2)E.
E.
Yeah. Yes.
All startup falling within the definition of as per Gazette notification, so and so, or as amended from time to time, are exempted from meeting the qualification criteria in respect of prior experience, prior turnover, as per para 3(2)A, subject to their meeting the quality and technical specification. However, the employer reserved the right to deny such exemption to startup where MSME or otherwise in case of circumstances like procurement of item related to public safety, health, critical security, operation and equipment, etc. Now kindly see 3.2a, my lord. Page 44.
Yes.
To qualify for award of the contract, each bidder should have achieved in any 1 year in last 3 years of minimum financial turnover for last 2 years. This is regarding turnover. This is exempted. Now,
To qualify, each bidder should have achieved in 1 year of the last 3 years.
yes. Number B, satisfactory completion in the last 5 years ending with last day of month previous to the one in which tenderers are invited, at least one similar work equal value to 80% of the estimated cost of the work, or two similar work each equal to value to 50% of the estimated cost of work, or three similar work each equal in value to 40% of the estimated cost of works. Similar work means so and so.
This A and B is in respect of experience and turnover.
Experience and turnover. And C is related to contractor registration based on experience, my lord. Class 1 contractor cannot be given to an
The bidder must be registered
contractor
with any
with
government, semi-government, so and so, allowing the understanding the work equivalent estimated value shall be submitted along with the bid.
yes. So as per class 3.2e, since I am a startup, my registration is under the startup registration. I have submitted bid.
There are three qualifications provided for a person to qualify for award of the contract.
Yes.
Here, one is turnover, another is experience.
Yes. Another is
Third is
registration.
registration.
Now,
Two, as per 3.2E, two have been exempted,
two
exempted,
exempted.
but not three.
Now question is 3. If it is not exempted, then also I have submitted class 1 contractor's registration
Of one proprietorship.
as my proprietorship. And that will carry forward to my partnership, because kindly see page 137 of my reply to their query, my lord. 137. The startup registration and the contractor registration are two different matters, but you have mixed both. I have given such clarification separately. As regard to startup is also a contractor's registration which enable us participating in any bid value of rupees 0 to rupees 100 crore. And Government of India issued this to me. Therefore, we fulfill the contractors as mentioned in clause 3.2a of the NIT, so and so. As per startup registration, I am eligible to undertake civil and electrical works of either government or private sector. The relevant scenario screenshot is attached. So in startup case, contractor's registration is null and void. Now comes to NIT so and so 3.2ac. Clause 3.2ac linked with 3.2a B of NIT, which relates to turnover and prior experience. And as such case of startup registration will be treated as contractor's registration, and you admit the same. Therefore, you have removed the clause 3.2ac from your so and so NIT. Now, as regard the contractor's registration, I have to start up the Prashant Saurabh is the bidder, because in the partnership deed, Mrs. Prashant Saurabh is the authorized signatory and holding 51% share in such partnership firm. And you have also asked to power of attorney, as I have given you a power of attorney, where I am the competent person to execute clause 3.2a of NIT so and so.
Yes.
Now, another aspect, my lord, kindly see bid, page number 42, last date of submission of bid. 6/8/2022, Roman 3. And to about the respondent number 7, what they have done, initially their bid was rejected on the ground that EPF certificate in the name of Brahmaputra Consortium has been.
We'll come to his case later on. First,
Yes.
Satisfy your.
My case. Now kindly say, I will show one judgment whether my proprietorship's registration will carry forward to this my partnership or not. 1995, my lord, Supreme Court, New Horizon case. Reason no. No. 1995, 1 SCC 478. Paragraph 23 can New Horizon, 1995, 1 SCC 478. Even if it is assumed that requirement regarding experience as set out in the advertisement dated so and so, inviting tender is a condition about eligibility for consideration of their lordship got it.
Yeah.
Though we find no basis of the same, the said requirement regarding experience cannot be considered to mean that the said experience should be of the tenderer in his name only. It is possible a visualization situation where a person having past experience has entered into partnership and the tender has been submitted.
Experience is altogether different. Registration.
My lord, what happened?
Registration.
Registration. My lord, when I registered as a startup registration, their partnership is one of the essential qualification to enter as a partnership. So I
And they granted you opportunity to get yourself registered as a, that opportunity was also granted to you.
registered
To avail that opportunity.
registered with respect to class 1 contractor. Class 1
Startup company to
That-
be registered.
that I have submitted.
Class 1 requirement was of class 1.
Class 1 question of class 1 registration will come, my lord, if I gathered experience in the work. As a startup, my lord, kindly see this certificate issued by the government of India as a startup, my lord. That certificate I have submitted.
3.2 AC.
See,
What is this condition?
condition is contractor's registration as a class 1.
Class 1.
Class 1.
That is you are not.
I have submitted as a proprietorship.
Proprietorship firm, they have asked for startup company, sir. Strictly speaking, you can't go into all this. They are the best judge or persons to interpret the documents of the or conditions of the tender.
And that was initially that was accepted.
That was accepted.
Subsequently,
respondent 7 bit was declared as non-responsive.
yes.
Ultimately, he made a representation and they found, yes, it is fault.
No, that is why I am showing, my lord. Kindly see page 1 page. I am showing, my lord. What was page? Kindly see, my lord. EPF registration in their EPF registration page 66. Kindly see when they have done it. Page 66, my lord. Kindly see.
Yes.
This page 66 tender was closed on 26/8/2022 and they have done it on 15 September 2022. 15 September. March after closing of the tender.
Of all, sir, to to come to this argument, first you have to pass your hurdle.
My hurdle is, my lord,
That you were not registered, then only we'll consider whether his tender was rightly accepted or not. First of all, you just.
my submission is when I have registered myself as a startup, that itself is the one of the requirements that I need not require to submit separate contractor's registration as per clause 3(2)(e). And even if it is requirement, then also my proprietorship will carry forward to the partnership.
Experience is altogether different, but registration as a contractor, that can be very problem.
My submission is that as a class 1 contractor, my lord, as a class 1 contractor, suppose today startup means it is a new concept, my lord. Is startup today startup a business? Now, on the very first day, he will not get the class 1 contractor certificate. He will not get because it is a startup company. Now, after when I have applied for startup, there is some requirement. In that requirement, my past experience was considered, and on the basis of that, startup registration has been done. And in the case of my lord Ma Durga construction, there also that credential of the one of the partners is to be considered for the purpose of partnership in participating in the.
You mean to say that a startup can't get this class A registration or class 1 registration on the day of registration?
Yeah.
And you should have challenged this condition. In the tender
My lord,
itself. You should have challenged why this condition,
my lord,
not be able to get this.
it is in my representation in page 137, when I have raised all this issue, in subsequent contract, they have abolished that terms. That
What
I am
about
not.
In this contract?
In this contract, no, in this contract.
Then
Now kindly see page, the Ma Durga construction judgment, my lord, page 4, my lord.
yeah.
Second paragraph, my lord.
Yes.
It was further submitted that fact that the experience of a partner in the experience of partnership fund is the foundation of the decision. The New Horizon case so and so, on the basis of which this court held that experience of one of the constituents of the joint venture is the experience of a joint venture. Further, according to the learned counsel for the appellant, the High Court failed to give error in holding that experience is something that cannot belong to the firm as assets, and for this purpose relied on provisions of partnership so and so with regard to property, and it came to
This
the
is the argument.
yes
Finding of the
findings. Yes, findings. This is the argument. Page 8. it is clear that in view of the High Court that experience is something which cannot be assets of a firm and therefore not capable of being attributed to firm is not correct. It is a settled law that partnership has been held to be competitious name of its partner, and that experience is a human attribute which does not form part of the assets or property of the firm in the usual sense. This is also an obvious since it is not, and in any case not capable of distribution of assets on the dissolution of firm. The court in New Horizons so and so, while considering the requirement of the experience, it has to be borne in mind that the said requirement is contained in a document inviting offer for commercial transaction. The terms and conditions of such document have to be construed from the standpoint of the prudent businessman. When a business enters into a contract whereunder some work is to be performed, we seek to assure himself about the credentials of the person who is to be entrusted with the performance of the work. Such credentials are to be examined from commercial point of view, which means that if the contract is to be entered with the company, he will look into the background of the company and person who are in the control of the same, their capacity to execute the work. He would go not by the name of the company, but by the person behind the company. While keeping in view of the past experience, he should also take note of the present state of the affairs and the equipment and resource at the disposal of the company. So my humble submission is that I, Prashant Saurabh, was a 51% shareholder over this partnership, and I have full control over this company, this startup. So my past credential is to be considered for the purpose of.
That's all?
Yes.
Yes.
May please, yes. My Lord, first of all, insofar as the startup thing is concerned, my Lord, they took all the exemptions for a startup, including exemption from depositing the EMD. When it came to registration, my Lord, they tried to fall back on the registration of one of the members of the startup, my Lord. So after having availed that benefit, now to again say that they should, insofar as certificate is concerned, you should look into the credentials of my partner would be in a way to approbate and reprobate, my Lord. Secondly, what had fallen from your lordships, my Lord, they were well aware of this particular requirement figuring in part 3 of 3.2a, and that is also something which the learned single judge had taken note of in para 17, my Lord. Now, my Lord, so far as 3.2.e is concerned, that the language is very clear, my Lord. The exemption is only in respect of, if I may just draw your lordship's attention to 3.2e, my Lord. So all startups falling within the definition as per Gazette notification so and so as amended from time to time are exempted from meeting the qualification criteria in respect of. So some meaning has to be assigned to that phrase, Lord. Lord, lastly, insofar as New Horizon and Ma Durga is concerned, Lord, like your lordship has already observed, experience is held to be a human attribute, Lord. Which is why it was said that the partner's experience can be something which can be taken note of. My Lord, we cannot perhaps draw the same analogy insofar as registration is concerned, my Lord. And my Lord, lastly, my Lord, the NHPC being the author of the document, my Lord, they are the best judge and they perceive 3.2e to mean an exemption only in respect of turnover and experience, my Lord. My Lord, so far as my qualification is concerned, my Lord, there were some questions raised on that. In fact, my Lord, this is for construction of an embankment ranging 30 kilometers odd, my Lord. Now, this contract has been distributed in packages, my Lord, and there are several packages for each of the stretches, my Lord. But the same issue was raked up in respect of another stretch, my Lord, where your lordships had decided that insofar as my EPF is concerned, there is absolutely nothing wrong with that. And the power of the authority was vested with the adequate power to review its decision if the need so arises. That was a decision which your lordships had rendered in another writ appeal, my Lord. There was a challenge by another bidder in respect of another stretch. The contention regarding EPF registration was raised at page 8, the second paragraph.
Page
8, internal page 8.
Yeah, the
Second para onwards. It is contended that in the present case, the TEC in its meeting dated so and so has declared the bid submitted by respondent number 6 herein as non-responsive, as it had failed to furnish EPF certificate in its name. Later on, the TEC has treated the bid of the respondent number 6 herein as responsive solely on the basis of the EPF payment challan bearing the name of so and so. It is submitted that the EPF registration certificate in the name of Brahmaputra Infrastructure has never been submitted by the respondent number 6. In such circumstances, the bid submitted by the respondent number 6 herein was liable to be treated as non-responsive, but the TEC in its report dated 10/11/22 has illegally treated the bid of the respondent number 6 herein as responsive solely on the basis of the EPF challan. This issue was negated at para 10, my lord, page 11. The TEC in its meeting dated 29/11/22 declared the bid of the respondent number 6 as non-responsive on the ground that it had not submitted the EPF certificate in its name, but had submitted the EPF certificate in the name of another company, Brahmaputra Consortium Limited. When the matter was placed before the manager of finance, he noticed that in response to the email dated 13/10/22, the respondent number 6 herein had submitted the EPF challan, wherein the code number of the EPF registration certificate and the name of Brahmaputra Infrastructure Limited were reflected, and therefore he had suggested for review of the case of respondent number 6. Pursuant to the suggestion of the manager of finance of NHPC, the TEC in its meeting dated 10/11/22 had reviewed the case of the respondent number 6 herein and decided to treat its bid as responsive while observing as under. Then in the letter is quoted. From the above observations, it appears that the earlier EPF registration certificate issued in the name of Brahmaputra Consortium Limited was changed to the name of Brahmaputra Infrastructure Limited by the EPFO Regional Office, Delhi, and the same was available with the NHPCL in its record pertaining to the earlier NIT dated so-and-so, when the EPF registration certificate in the respondent number 6 herein was already available with the NHPCL, which was issued prior to the last date of submission. No error can be found in the decision of the TEC to take into consideration the same. Then, my lord, it has also been discussed that submission of EPF cannot be termed as a material deviation. So I, in any case, remain eligible, my lord. My even otherwise, it's an infrastructure project, my lord. This it's a dam, my lord, and it's connected with the larger project of the hydroelectric project at Subansiri. So there's an element
you
of.
are appealing for,
I'm for the respondent number 7.
and other respondents?
NHPC, after issuance of notice, they will appear, my lord, because the council who are engaged in the each petition, I offered, but said that no.
Isn't it now? Without hearing the other part.
It is up to your lord. My lord, another thing, my lord, the review which has been done only with respect to my and the respondent number 7, not other cases. There are 7 bidders. Review has not been done in all other cases.
In those cases, when they has to come.
Yes, But so
Then
far,
those persons, if aggrieved, then they has to come.
I was not aggrieved. I was not aggrieved.
You were not aggrieved, but if they are aggrieved by them.
Yes,
then
they,
they'll come
they
and-
were aggrieved to favor them. My review has been done because I was declared as responsive. I was declared as responsive. But so far as a review part is concerned, my lord, only they selectively reviewed the two persons, the petitioner and his case. And with respect to other bidder, no review has been done.
My lord, para 12 of the other judgment, my lord, also discusses the manual, my lord, whereby the authority is vested with the power to seek clarification and also review.
This writ appeal is triggered. Appellant being agreed with the order dated 132, order dated, the judgment dated 21/11/2024, passed by the learned single judge. And writ petition number 132 of 2023. The appellant has approved the report being agreed with the action of the respondent NHPCL. The authority, tender evaluation committee, who is the tender?
NHPCL.
NHPCL. And disappear. On an NHPCL,
Respondent number 2.
action of the respondent NHPCL, whereby the bid submitted by the appellant in response to the NIT dated
4/8/20.
4/8/2022.
4/8/2022 for the work of river in inverted commas river bank protection / erosion control measures on the left bank of river Subansiri downstream of village Gerki 1 in bracket RD 28 kilometer to 29 kilometer. ये इसमें पैरा नंबर 3 में से होता है इस for the work. The technical bid of the petitioner was declared, of the appellant was declared non-responsive on the ground that the bidder has not furnished the registration certificate of its startup company with any government / semi-government department / NHPC registration. Declaring it or verifying it as class 1 or class A type contractor. Full stop. The appellant has argued before the learned single judge that as per the exemption granted to the startups White clause 3.2E, the appellant is not required to submit the registration class 1 or class A certificate, registration of contractor as class 1 or class A. It is also contended before the learned single judge that prior to the registration of the appellant startup as MSE, the appellant company was a proprietorship firm which was duly registered as class 1 or class A contracted firm, and for the purpose of meeting the qualification specified in clause 3.2.A in bracket C, the said registration certificate of the proprietorship firm is required to be taken into consideration. The learned single judge have the required to be taken into consideration. Would stop. The appellant has also questioned the decision of the NHPCL of treating the bill submitted by the private respondent number 7 as responsive. Technical bid submitted by the respondent number 7 as responsive. The learned single judge, after taking into consideration the submissions of the rival side, has dismissed the writ petition by passing the impugned, dismiss the writ petition. The relevant extract of the impugned judgment is reproduced here under para number 18, 19, 20, 21, 22, 23, and 24. Learned counsel for the appellant has submitted that the learned single judge has not taken into consideration the fact that the registration certificate of the proprietorship firm was required to be, was not required. The registration certificate of the startup, the appellant startup MSC is not required to be furnished in view of the clause 3.2.E of the bid document. It is also submitted that even though if it is assumed that the same is required to be submitted, then the certificate of class A registration of the proprietorship firm is required to be taken into consideration because the same relates to one of the partner of the startup appellant in learned counsel has submitted that the Honorable Supreme Court in horizontal New Horizons Limited and another versus Union of India and others reported in 1994-0. The Supreme Court SC so and so has laid down that experience of one of the partner of the company company is required to be taken into consideration as while determining the experience of a company. Stop. The net counsel has further submitted that the Honorable Supreme Court in Man Durga Construction versus Saroj Kumar Jaina and others, yes, that for a detail, has reiterated the said position of law. It is also contended by the learned counsel for the appellant that as a matter of fact, a newly registered startup company cannot obtain a class A or class 1 or class A registration certificate on account of lack of experience and when the appellant has raised this specific objection before the NHPCL, they have removed the said condition in the subsequent NITs. It is submitted that in view of the above fact, it can be assumed that the said condition of submitting registration by a startup company as class 1 or class A contractor is not mandatory. It is contended that the learned single judge has not taken into consideration the above aspect and therefore it is also contended that the learned single judge has not taken into consideration the fact that the has not rightly appreciated the fact that the respondent and NHPCL has illegally declared the technical bid of the respondent number 7 as responsive, though admittedly he has submitted the requisite documents after the last date of submission of the bid in response to the NIT in question. Stop. Learned counsel appearing for the respondent number 7 and judgment and has argued that there is no illegality in the impugned judgment passed by the learned single. Stop. Third, learned counsel for the party and peruse the material available on record. It is not in dispute that the appellant has failed to furnish the registration certificate of the appellant startup as a class A, class 1 or class A contractorship form. Stop. having carefully examined the clause 3.2.a in bracket C as well as 3.2.e, we are of the view that the learned single judge has rightly come to the conclusion that the exemptions granted to the startup companies is only related to the prior experience and prior turnover. The condition of submitting the registration as a contractor, registration of a SME or of a startup as a class 1 or class A contractor is not exempted. Full stop. We are also of the view that the learned single judge is rightly observed that there is no illegality in the action of the respondent and NHPCN to declare the bid submitted by the respondent number 7 as responsive because the responsive because earlier they have failed to take into consideration the fact that the documents regarding the registration of the respondent number 7 were already available. Stop. Having were already available. So far as regarding the judgments on which the learned counsel for the appellant has placed, judgments of the Honorable Supreme Court on which the learned counsel for the appellant has placed reliance are concerned. The same as been taken into consideration by the learned single judge and has rightly been distinguished from the facts and circumstances of the present case. In view of the above discussions, we don't find any merit in this appeal. The same is therefore dismissed. शुरुआत में
Deeply.
शुरुआत को लेते हैं. Dismiss as motion itself, stage itself, looking to the fact that the matter is regarding the award of contract in relation to an infrastructure project with the consent of the parties. We have heard this matter finally at motion stage.
Much obliged.
Item 16.
Lordship, I writ appeal is preferred against the order dated 13/12/2024 by the learned single judge, whereby the honorable single judge had taken an erroneous view.
Erroneous.
Yes, Lordship, because we have not prayed for before the honorable single judge for stay of the project, Lordship.
Then
Only for re-evaluation of the re-evaluation of the property, Lordship.
realignment of the road.
Realignment in front of our land, Lordship. Only
You want that whatever this real alignment is done by the NHA.
it is, Lordship, it is in nascent stage of the land acquisition process, Lordship. And land acquisition notice was issued only 11/10/2024, Lordship. Prior to that, Lordship, the authority have entered in our property in the month of April 2000. It is clear violation of the statute, Lordship, under section 3B as well as 3C, etc. Subsequently, after entering, they took measurement and survey and demarcation of the land. Thereafter, the notice was issued under section 1110, Lordship.
So how you are agreed by this order, madam?
Agreed, that order is only for that the learned single judge mentioned about we are opposing. We are not opposing the entire land acquisition process.
Tentative observation, it is not decided till date.
No, but in the meantime, they will issue notice under section 3D, Lordship. If the authority issue notice under section 3D, that amounts to, Lordship, my whole case become infructuous, Lordship. That is why I pray that till then.
It has not been decided 13/12/2024. It will be listed in the second week of January. You can very well pray for a stay or whatever it may be. Still, the writ petition is pending.
Yes, Lordship.
So how we fail to understand the court has issued notices to the respondents. How you are agreeing by that?
Because, Lordship, if the interim order is not passed by the honorable
Interim
court, they
order
will
has
issue.
not been refused. You can very well pray for that on the next date of hearing. That has not been
It will be listed after 4 weeks, Lordship. On that day, I prayed before the honorable court.
2024. Now 4 weeks before 30th of January, it would be listed.
But Lordship, it is, they have taken a measurement, they have rejected, the authority has rejected my objection petition, Lordship.
Alignment of the road is concerned, this court has no jurisdiction.
Yes, Lord, I know when there is, yes, I know about that, this court has limited scope for judicial
Not at
review.
all, no scope. It is only for these highway people. They can only, they are the
Yes,
best
Lordship.
judge.
Yes, Lordship. In that case, Lordship, if the statutory provision is violated, then this honorable court has power. Earlier, twice, Lordship, our land has been acquired. Only as
So far as regarding this appeal is concerned, how this appeal is maintainable, still the writ petition has not been decided.
Only for-
Notices have been issued.
Yes, Lordship.
Even though if the learned single judges incorrectly recorded your argument, that how it will affect, you can very well correct the learned single judge at the time of hearing of the petition that this is not my argument, this is not my case, this is the case.
Yes, Lord, till then, Lordship, my simple prayer that no notice under section 3D may be issued, Lordship.
Pray before the learned single judge, he'll consider it. If he'll not grant and then you come to us, we'll consider it. Still that, whatever your prayer has not been rejected by the learned single. It is not that case that he is passing.
But Lordship, the learned single judge had taken that view while arguing that on that point,
No
Lordship.
such view, ma'am. Where is the learned single judge opine anything?
Nothing has been recorded, Lordship, about that.
Issue notice to the responsible.
Yes, Lordship.
MR Adhikari, learned so-and-so appear,
Yes, Lordship.
accept notice, Mr. So-and-so accept notice, Mr. So-and-so. Notice as such, no formal notice issued, however, requisite extra copies furnished by the 3 days, list after 4 weeks. That's the only order.
It is for second line, as such, this, she submits that the construction of the proposed Guwahati Ring Road project may be staged. I have not prayed for any, there is no prayer
Maybe
to.
you can very well clarify before the learned single judge that you have wrongly recorded this, but there is no finding in respect of your argument. They have simply recorded their argument.
Lordship, but the authorities, they have entered into, they have started everything.
You approach the learned
That is why if they issue section D notice, I cannot,
What is the illegality in this order? Issuance of notice to the respondent, is it illegal?
that is not illegal. Regarding limit, I have also limited prayer before this honorable court for only not to issue that section D, 3D notice.
It very well move an application.
Lordship,
of
kindly-
urgency before
kindly-
The learned single judge can't, we don't find any illegality in this order. You can very well, if you have urgency, you can very well move an application before the learned single judge immediately on reopening of the court or even tomorrow, that please hear this matter and pass some order. Still that course is open to you.
But my NHA authority there,
Sorry for it. Under section 3D, already a notification issued on 4th December. Already issued on 4th of December of this year, 2024.
4th of December.
Already been issued, my lord. His acquired land is been, schedule is here, my lord. It's already been
And
issued.
what remains then?
Then not, even.
we do not know.
It's not, so it's a notification. If it
Yes,
is issued,
notification.
Because
Lordship.
as TD is over, it is vested to
It's
central
a gazette
government.
notification.
We
Yes,
have
my
no knowledge.
We don't know.
Lordship, we have knowledge. We
Knowledge,
do not have any knowledge about the notification of later.
Then you approach the learned single judge for the case. Yes. We will grant you liberty, withdraw this, we will grant you liberty to approach the learned.
Yes, Lordship.
So attempting to argue the matter, argue there with the field for quite some time, and the concept of the particular on instructions. Appellant on instructions has submitted that she does not want to. She does not want to, she wants to withdraw this writ appeal with liberty for the appellant to approach the learned single judge. To pass appropriate order on the prayer of the interim application in view of the subsequent developments. This with liberty as prayed for.
Obliged.
Obliged. I'm making it.
Item 17.
May it please your lordship. There are 2 caveats also. 3 caveats. So the appellant before your lordship is a joint venture company consisting of 3 companies, lordship. The work is relating to carriage of coal from Coal India's colliery in Amargherita for a period of 10 years. There were 12 bidders. 10 bidders were outrightly rejected. And out of the remaining 2, I am one. And I was given an opportunity to rectify certain things, which I have done. One I could not do because there is some glitch in the portal. But those clarifications and those shortfalls were also not required at all. That is my case. My bid was considered to be non-responsive on 2 counts. One is that one joint venture agreement I have to submit. That is not as per the wordings of the pro forma agreement. There were 7 additional words, and in the pro forma agreement, lordship, there are 15 paragraphs. In my agreement, there are 17 paragraphs. But my submission before the learned single judge was that there is no material difference or deviation regarding the content and tenor and meaning of the affidavit. And the other part is that I have to submit a local content certificate. We are 3 companies who are part of the joint venture. Out of the 3 companies, we have submitted 2
local content certificates, one having 100% local content, then the other one is having 50. The requirement is that joint venture must have 50% or more. So they said that you give a certificate of the joint in the name of joint venture. On 15th of August, the last date was 5th of August. On 15th, they said that you give a joint local content certificate in the name of JV. Local content certificate. That they are doing some business and they have to procure some locally made products under the Made in India scheme, Lordship. So I submitted the fresh certificate from the chartered accountant, which is as per the requirement on 17th. The learned single judge held that is a document which I cannot submit after the last date was over. My first submission is that if a joint venture's local content certificate is required and if it is given in the name of the constituent of the JV, that will suffice. Just now, Lordship has dealt with that kind of issue. That New Horizon case also we have placed. We have placed 4 other judgments, but we could not furnish a judgment which my learned friend in the earlier 2 cases has the second one, which is not reported. So in respect of experience, Lordship, the eligibility criteria, Lordship, will find at page. Yes, page 140. 2.2 joint venture / consortium. 2 or 3 companies contractors may jointly undertake contract. Each entity will be jointly and severally responsible for completing the task as per the contract. We are concerned about 2, Roman 2. The qualifying criteria parameters, example, experience, financial resources of the relevant period, and the equipment fleet strength of the individual members of the JV consortium will be added together, and the total criteria should not be less than as spelled out in qualifying eligibility criteria as specified in additional terms and conditions / bid document. However, the required working capital shall be made by individual members of the JV consortium as spelled out in the relevant clauses. Roman 3, the formation of the JV consortium or change in the JV consortium character after submission of the bid is not permitted. We are not concerned with that. 4, the bid and in case of successful bids, the agreement shall be signed so as to be legally bind all members jointly and severally, and any bid shall be submitted with a copy of the joint venture consortium agreement, provided that the joint and several liabilities with respect of the contract. So if we look at Roman 2, Lordship, that whatever experience regarding, the examples are given regarding experience, financial resources, etc. Our 2 companies of the joint venture, one had 100% local content, the other had 50%. Jointly, if we do the calculation, it is also said that they has to be added together. So if we add 100 plus 50, 150, and if we divide it by 3, then it is 50. So subsequently, we submitted a certificate according to their requirement. But that was a subsequently.
What was the requirement?
The requirement is that according to them, it should be in the name of the JV. Joint venture. That means the appellant's name, JRPL, JWP, and DMC. What we have given JRPL and JWP individually. That is the law is well settled, Lordship, now. That in case of joint venture, whatever may be the language of the NIT, if it is joint venture, Lordship, for so far as calculation of the experience and etc. Page number 2. Yes. So what I have submitted, Lordship will kindly come to page 282. So this is a local content certificate as per Annexer Roman A. It is 100%. The third line from below of paragraph 5.
No, first of all, you just, what are the names of this companies who have created a joint venture?
Joint venture. One is Lordship, JPW Infratech Private Limited.
JPW
Infratech Private Limited.
Private Limited.
Then MS Joy Ambe Road Lines.
Jai Ambe Road Line.
Yes, Lordship. Private Limited. And last one is Dev Mining Company. Dev Mining Company.
Dev Mining Company.
Lordship.
Yes.
Now, Lordship will kindly come to page 282. That is the local content certificate issued
No, and you have submitted the bid in the name of?
in the name of the lead partner.
JV,
That is, there is no dispute on that. There
JP
is no quarrel on that.
JPW Infrastructure Private.
Yes.
Yeah.
So 282 is the local content certificate in respect of JPW Infratech Private Limited, wherein it has been very clearly stated that the local content is offered products, services, etc. of JP Infratech is 100% and meets the local content requirement for class 1 local supplier. That is number 1. And number 2, Lordship will kindly come to 280. The type copy, 217 is the original. 50% yes. The last paragraph of this 280, local supplier means a supplier or service provider whose goods, services, or work offered for procurement of has local content 2 or more than 50% as defined under the said order. So we submitted these 2 certificates. Then there is a objection from their side at which Lordship will find at page 278. The last one, request number 1 is at bottom.
278. Yeah.
Here, clarification is requested. You are requested to submit the certificate in the name of JARPVL JPW DMC issued by the practicing cost accountant or practicing chartered accountant regarding the local content as per Annexer 9A of the FTC. So this is the first requirement we have to fulfill. And this was updated 15th of August. So what we have done, yes, as per we have submitted a fresh one from the chartered accountant, which Lordship will find at 279. Now this is in the name of the JP. Actually, this is not required in terms of the settled law regarding JV's operation. But however, they requested and we submitted this also.
This was the condition mentioned in the tender or not?
No.
No such
No.
condition was there.
That is where the learned single judge committed the mistake. And JV for the first time has been constituted for this work. How can they have a certificate without working together? So this is the main core issue, moot issue is this, Lordship. And why?
You are not put by the learned single judge only on this ground that.
No, there is another ground. There is another ground. This is, and we have issued, submitted this certificate of 17th August. That date is important. The query was of 16th.
Which certificate?
That certificate page 279.
This you have submitted.
We have submitted finally.
They have asked to submit it.
And we submitted, but they wanted their post-dated certificate, which we cannot do. The law, the condition of the tender is very clear. If Lordship is pleased to come, that when there's a shortfall, they can ask for clarification or they can ask for additional documents.
This communication is dated 278 communication.
Yes, it is of 16th August. There is no dispute on that.
August.
Yes.
Okay.
That is, last date was 5th August.
You are requested to submit a certificate in the name of so and so, the chartered accountant, so and so. And pursuant to that, you have submitted it on
17th. So they found now fault with the date. If it had been prior to 5th of August, they would have accepted it. It is 17th. It is subsequently procured certificate.
This was not the condition in the tender.
The condition is very interesting, Lordship. I'll take your Lordship to that. If there is any shortfall, without changing any data, quantity.
In the tender document, there is no condition that certificate in the name of these three forms
Is required? No.
No such.
Lordship may put the direct question to them. So far as local content, no specific.
And another reason?
Another reason is that 7 additional words we have inserted in our joint venture agreement. The joint venture agreement wants that all the partners, all the constituents of the JV must be jointly and severally responsible for any damages.
Right.
3 paragraphs we have written, same meaning. And in 1 paragraph we have said in terms of the clause number 4. In clause number 4, again, it is the same thing.
What was the condition of the tender?
Condition is like this, that we have to submit it as per the pro forma.
As per the performance.
Pro forma.
And admittedly, you have not submitted as per performance.
As per, absolutely not. Lordship,
Meaning.
there's a deviation. There's a deviation, but there's a clause in the agreement, in the NIT, that you have to comply substantially to all the conditions. There should not be any material deviation. Clause 22. By adding those 7 words, Lordship, there is no change of the meaning of the joint venture agreement. And on top of that, they have accepted it. The problem is that they have accepted it, and the query, which I have just placed to page 78. 278. Lordship will kindly see. There are 3 requests from their side. First request I have just indicated, Lordship, regarding the certificate.
Yes.
Second is that one of our certificate was not legible, so we have.
In this 278, you are requested to submit clearly readable copy of the.
Yes, that we have done. There is no dispute.
Okay.
And third, request number 3. Here, Lordship will kindly note, clarification description due to text limit, the GM portal, the query is attached.
Additional document required in ATC.
Due to text limit by the GM portal, the query is attached. So that query was never opened. We could not open it. And till now, they have not refuted, Lordship. Now, rejection of case to rejection. Final rejection. Yes.
This Request number 3 is, what is this request number 3?
That is what we have come to know later on, that they want a clarification regarding the consortium and joint and several responsibilities, liabilities. Now we have come to know that they want a clarification. They have accepted our joint venture agreement, but they were a little bit confused about those wordings. Paragraph 6, paragraph 7, and paragraph 4. They want a clarification. That means they have accepted it. They have not rejected, and they have not asked for giving a fresh document also. So they wanted a clarification, which we could not clarify at that relevant point of time, because the portal, the detail of the query was not there. We could not open it, and there is no scope of giving any notice to them. Because the portal, it is not operatable both ways. It is one-sided. And after rejection on 22nd of August, on 23rd, we submitted a representation saying that whatever clarification you need, we can give. Whatever regarding those local contents also, we have described our stand. But we have not mentioned, the learned single judge just found fault in us, that in the representation, we have not mentioned that the portal was not opening regarding the attached file. That thing, but in spite of everything, Lordship, and what we have done, when we are uploading the legible copy as per request number 2, as well as the certificate of 17th August 2024, Lordship, regarding the local content in the name of the JVC, we have uploaded both. Then in respect of query number 3, which is not forthcoming to us, we cannot clarify also. So what we have done, we have submit, if we have to upload one particular document, any document, then only the other twos will be accepted. So what we have done, we have the working capital certificate, which has nothing to do with this query. We have uploaded so that our 1 and 2 queries are properly accessed to them. Lordship will kindly come to page 286. The reasons of the of our rejection. On 22nd, disqualified. As per the document of local content submitted against the clarification is dated 17/8/2024. 286, Lordship.
Yes.
As the document of local content submitted against the clarification is dated 17/8/2024, which is after the bid submission end date 5/8/2024. And the second is, the submitted document regarding consortium agreement is not in line with the format provided in Annexure 2 of ATC of documents. Therefore, you are not fulfilling the eligibility criteria as per requirement of the bid document. So far as first is concerned, I have already made my submission. So far as the second is concerned, Lordship, now in their affidavit, they have clearly said that we sought a clarification regarding clause 7, 6, and clause 4.
From whom?
From us, as per the query number, request number 3. That clearly indicates that they have accepted our joint venture agreement. That means it is accepted. So if a clarification is given, Lordship, that is just to clarify. And on top of that, one of the condition is that this joint venture agreement is to be submitted prior to the finalization of the bidding. And after the bidding is over, and if I am successful, I have to execute a fresh joint venture agreement. What they exactly want from the joint venture, that we are the parties and we are responsible for the work at the time of processing and tendering, as well as if the work is allotted to us, we'll take responsibility of completion of the work. Everything is clearly discernible from the language as well as the wordings. What additional words we have inserted? Let us place that, Lordship. Please 124. Paragraph lead page 126, relevant portion, Lordship, where there is a confusion to them. not to us, and it will not be to anybody else. The whole intention was to oust everybody, and only one blue-white person, they have to get the contract. And my bid is 112 crores less.
That hardly.
That
hardly met.
that
They are only concerned whether you have complied with the.
yes, Lordship.
or not.
Oh,
So,
yes. Now, Lordship will kindly see clause 4. Lead partner. JWP Infratech shall be the lead partner of the consortium and is in charge of performing the contract management. So and so shall be the attorney of the parties duly authorized to incur liabilities and receive instructions, and on behalf of any and all partners of the consortium, and this is very important, all the partners of the consortium shall be jointly and severally liable during the bidding process and for execution of the contract as per the contract terms and of the employers. All consortium partners, Joy Ambe, JPW and DMW, nominate and authorize Sri Joy Prakash Wasan, Director JPW, to sign all letters, correspondence papers, etc., and to submit the pre-qualification application, bid document, etc. Now, Lordship will kindly come to 6. 6. Participation and share of the work responsibilities. We have given the 3 partners. One is 50%, one is 30, and the other one is 20. They also want this also. Now, 7. Joint and several liabilities. All partners of consortium shall be liable jointly and severally to, as mentioned, proportionate clause number 4 during the pre-qualification and bidding process, and in the event the contract is awarded during the execution of the contract in accordance with the terms. So what we have added, severally as mentioned, proportionate clause in clause number 4. This is what is troubling them. Now, if we go to clause number 4, this is the previous page, lead partner, where we have very categorically stated all the partners of the consortium shall be jointly and severally liable during the bidding process and for the execution of the contract as per the contract terms with the employer. There is no change of any meaning. Only these 7 words. The learned single judge also said 7 words. And paragraph in the this pro forma agreement, Lordship will kindly come. Page 180. It starts at 187. And clause number 5, 189. All the partners of have Lordship got it? All the partners of joint venture consortium shall be liable jointly and severally during the pre-qualification and the bidding process, and in the event the contract is awarded during the execution of the contract in accordance with the contract terms. Here we have inserted these 7 words. That is in terms of clause number 4. Clause number 4 is the same. This had not changed any meaning. If we conjointly read, if we singly read any of this paragraph, there is absolutely no change. And I have a direct judgment on this. It is a curable defect. And they accepted it. They want clarification. In their affidavit, we want clarification, request number 3. So they do not want any change of my agreement. They do not want a replacement of my agreement. That means they have accepted it. They want a clarification. And on top of that, if I get the work, then a fresh joint venture agreement will have to be executed. That is as
the condition number, this clause 19 to second B.
A shortfall that. Yes.
Page
159. The second, page 160, the relevant portion is there. The shortfall. Yes, let me read, Lordship, from 19.
19.
Evaluation of tender.
Yes.
The Roman B, the B is important. In case the tender committee finds that there is some deficiency in uploaded documents corresponding to the information furnished in bid submission confirmation sheet, or in case corresponding documents have not been uploaded by bidders, then the same will be specified online by evaluators, clearly indicating the omission shortcomings in the uploaded documents and allowing 7 days, 7 into 24 hours time for online resubmission of bidders. Additionally, information shall also be sent by system generated emails, SMS, which has never came to me at any point of time. Be it the bidder's responsibility to check the updated status information on GEM portal regularly after opening a bid. No separate communication will be required in this regard. Non-receipt of email and SMS will not be accepted as a reasons for non-submission of documents within the prescribed time. The bidders will upload the scanned copy of all those specified documents in support of the information declaration furnished by them in bid submission confirmation sheet within the specified period of 7 days. No further clarification shall be sought from bidders. Now, this is important, Lord. The shortfall information documents should be sought only in case of historical documents which pre-existed at the time of the tender opening and which have not gone under change since then. Pausing here for a moment, this is one part. Now coming to the next part. This should be called only on basis of recommendation of the technical committee, tender committee. So far as submission of document is concerned with regard to qualification criteria, ours is qualification criteria, Lordship. That is the second part. So far as the submission of documents concerned with regard to qualification criteria, after submission of the tender, only related shortfall documents should be asked for and considered. For example,
At 2.
I was in page 160.
Yes.
So the shortfall information documents should be sought only in case of historical documents which pre-existed at the time of the tender opening and which have not undergone change since then. These should be called only on basis of the recommendation of the TC. So far as the submission of document is concerned with regard to qualification criteria, the 50% is a qualification criteria, Lordship. After submission of the tender, only related shortfall documents should be asked for, which they have done on 16th of August and considered. For example, if the bidder has submitted a work order document relating to a particular contract without its completion / performance certificate, the certificate can be asked for and considered. However, no work order for new contract should be asked.
Essentially, it says that the shortfall document should pertain to the should be existed prior to the submission of the bid or the last date of submission of the bid.
That is what the learned single judge held on the basis of the first line.
This, what you have read now, this para number 2. The shortfall information document should be sought only in case historical documents which pre-existed at the time of tender opening.
That is one part. But for the second part.
Second part, which part?
Second part. These should be called on the basis of recommended TC. Now stop. Then so far. Now it is a different.
Called only on the basis of the ticket. So far, as the submission of documents is concerned with regard to the qualification criteria after submission of the tender, only related shortfall document should be asked for and considered.
Now the example is there, very important. Example, if the bidder has submitted a work order document relating to a particular contract work without its completion or performance certificate, that means a performance certificate has to be procured thereafter. The certificate can be asked for and considered. However, no work order for new contract should be asked for so far as to qualify the bidder. My submission is twofold, Lordship. One is that under this clause also, if there is a shortfall, they can ask and I can give without changing the quantum of percentage of local content.
What we,
That was existing.
this is exactly what we are. That the shortfall document, whatever it may be, can only be submitted or considered which are pre-existed at the time of tender.
Lordship.
That is the, what we feel is.
Yes, that can be Lordship's opinion. That is fine, Lordship. Now my next line is that this subsequent document should not have been asked at all.
Which subsequent document?
The local content. Because I have submitted two documents which were pre-existed and pre-issued. One is of 12th of July and the other one is also prior to 5th of August. So I issued one is 100%, one is 50%. And if we combine it, it fulfills the eligibility criteria. So for a joint venture, it cannot be in the name of the joint venture because this joint venture has been worked out only for the purpose of this work. This is a newly created joint venture. In fact, they are asking in the name of joint venture itself is fallacious. It is not correct. They should not have asked because the law settled by New Horizon and all subsequent judgment as well as the tender condition itself.
Now, on two counts, your bid was declared as non-responsive or
Yes.
rejected. First, that you have not submitted that joint venture certificate, pre-existed joint venture certificate. This is the one ground.
Yes, this is one ground.
And second ground is that you have changed in the performa or whatever.
Pro forma order.
Now, so far as regarding second ground is concerned, you are also admitting that yes, there were changes. But those changes are of insignificant nature.
Immaterially insignificant.
Insignificant nature because the whole undertaking or whatever it may be that is very much in consonance with that so and so. Now, there is that condition which in the tender document which says that joint venture certificate of the joint venture company is to be.
That my learned friend will have to show because I could not find it.
Yes, Mr. You are for?
I am for Coal India Limited, the author of the tender document. My lord, so the most relevant clauses, tender clauses, and some of the relevant facts have not been placed. My lord, may I have take your lordship's?
I will hear you, but first of all, this second requirement that on the basis of which you have this non-suited appellant, that the joint venture certificate.
Local content certificate.
That joint.
Local content certificate in the name of joint venture.
Local content certificate in the name of that.
Joint venture.
This
Basically,
page number 278.
Yes.
You are requested to submit the certificate in the name of so and so, issued by the so and so.
No.
That is, this condition is, where is this?
My lord, if your lordship will first turn to the NIT, it starts at page 131.
131.
And the very next page,
Yes.
your lordship will straight away turn to clause 1 at page 132.
Yes.
This clearly indicates who are the bidders and how they are to submit their tender. Clause 1. Tenders are invited online on the website so and so from the eligible bidders. Your lordship should kindly note this, my lord. Eligible bidders. I'll come to that. Who are eligible bidders? The registration should be in the name of the bidder for individual, proprietorship firm, partnership firm, company registered under Companies Act. Whereas for participation of joint venture consortium through GM portal, the registration of bidder should be in the name of lead member of the joint venture consortium. And the next portion, the submitted document against eligibility criteria should be in the name of the joint venture. So
the documents proving eligibility have to be in the name of the joint venture, who would be an eligible bidder. Now, if your lordship will kindly come to the eligibility criteria, which your lordship will find at page 140. 140. First, clause 2, eligible bidders. 2.1, the invitation for bid is open to all bidders, including an individual, proprietorship firm, partnership firm, company registered under Companies Act, or a joint venture consortium. The bidders shall be eligible to participate only if they fulfill the eligibility criteria specified in bid document, additional terms and conditions, etc. Now, if your lordship will next turn to the local content requirement, which is part of this, madam. If your lordship will kindly turn to page 150.
Eligibility criteria, where is the eligibility criteria?
Eligibility criteria, I'm coming to that. 152.
152.
Your lordship is aware, madam, nowadays there is a lot of emphasis on the Make in India policy of the government. So this tender, only those who are complying with Make in India are eligible bidders. I'll come to that.
Eligibility criteria, where is the?
Eligibility criteria starts at, my lord, page 140, it carries on. If your lordship will kindly come to page 152, this is
140.
140, it starts, eligible bidders. And then eligibility criteria starts at 142, clause 3. Right in the middle of 142, your lordship will find
Just.
You really don't want to fear with the penny. More look of the fear. They may have come. Fine.
This come to page number 278.
Yes.
This last one, clarification description.
Madam,
What is it read?
you are requested to submit the certificate in the name of JARPL GPW DMC issued by practicing cost accountant or practicing chartered accountant regarding local content as per annexure 9A of the ATC PITO.
This, that is certificate by the cost accountant or chartered accountant, practicing chartered accountant. Where is this condition specifically mentioned?
Yes. It's there. Your lordship will kindly come to 152.
152.
150.
Yes.
Subclause R. This is specific to, my lord, that Make in India compliance.
R.
R.
Yeah.
Documents as required to comply with the order number so and so for preference to Make in India as applicable issued by the government of India as amended from time to time shall be submitted. In terms of the above said policy, purchase preference shall be given to class 1 local supplier. In terms with the above said policy, class 1 local suppliers and class 2 local suppliers shall be eligible to bid. Definitions of class 1 local supplier, etc., etc. Now, A, class 1 local supplier, this is what we are concerned with. Class 1 local supplier means a supplier or service provider whose goods, services or works offered for procurement has local content equal to or more than 50% as defined under said order. Now, what is local content is defined in the next page. Your lordship will kindly come to subclause D. Local content means
Yes.
local content means the amount of value added in India, which shall be the total value of the item procured, excluding net domestic indirect taxes minus the value of imported content in the item, including all customs duties.
Without going 152.
No, I am coming to the requirement of the chartered accountant.
Chartered accountant or that accountant?
Yes, Malal.
That.
So, page 153, clause B, Malal. Just
Clause-
below local content, whatever I was reading, Malal.
Clause.
Subclause B, in the middle of the page, there is a subclause B. If the estimated value of procurement, is more than 10 crores, all the bidders shall submit along with its bid a certificate with UDIN, annexure 9 capital A, from the statutory auditor or cost auditor of the company in case of companies, or from a practicing cost accountant or practicing chartered accountant in respect of suppliers other than companies, giving the percentage of local content. Now, since it's not a company, it's a joint venture. So therefore, this will be practicing cost accountant or practicing chartered accountant is applicable. And therefore, now below that, your lordship will find a note. The documents to be furnished by the bidder, your lordship will kindly mark this. The documents to be furnished by the bidder to prove that he is satisfying the eligibility criteria laid down could all be in the bidder's name, except in cases where, though the name has changed, owners continue to remain the same, etc., etc. So it has to be in the name of the bidder. And admittedly, the bidder is a joint venture. So what he originally did was he submitted 2 certificates by 2 of its partners, constituent partners. We said that to comply with, you have to submit a certificate by the bidder who is the joint venture. And that is the clarification that we sought. Now, when we sought for that clarification, what he submits is a fresh document procured subsequently, and which is not permissible. We cannot accept it because only historical documents that pre-existed prior to the date of the bid opening can be accepted. So naturally, we were compelled to reject that clause my learned friend had placed, that it is only historical documents which pre-existed on the date of the bid opening is a document that we can accept. Now, what was submitted is at page 279.
After this, which certificate he has produced?
Page 279.
279.
And admittedly, the date is 17th of August 2024, which obviously did not pre-exist on the date of the bid opening. Now, one of the arguments that has been sought to be developed is by application of the law laid down by the apex court in the case of New Horizons. In case of joint ventures, the experience of one has to be taken. That is, my lord, those have been incorporated in this NIT. If your lordship will just allow me to place.
In so many words.
Yes, wherever individually, like for example, a PAN card, the JV cannot have. So we allow that individually you can submit. GST registration, you can individually submit. But so far as this local content is concerned, it is expressly provided that it has to be in the name of the bidder. And admittedly, the bidder is the joint venture. Now, this aspect has been elaborately dealt with by the learned single judge. Now, the other document, it's very interesting, Malad. The other ground on which we have rejected, the clauses, relevant clauses, if your lordship will just quickly allow me to place those. If your lordship will kindly come to page 132. I'm sorry, Malad, your lordship will come to page 140.
Yes.
Clause 2.2.
Yes.
2 or 3 companies may jointly undertake contracts. Next sentence. Each entity will be jointly and severally responsible for completing the task as per the contract. Now, subclause 4. The bid, and in case of a successful bid, the agreement shall be signed so as to legally bind all members jointly and severally, and any bid shall be submitted with a copy of the joint venture agreement, providing the joint and several liabilities with respect to the contract. This is an express provision in the NIT. Now, the format is provided at page 187. The relevant clause that created the problem is at page 189. Clause 5.
Yes.
All partners of joint venture consortium shall be liable jointly and severally during the pre-qualification and bidding process, and in the event the contract is awarded during the execution of the contract in accordance with the contract terms. Now, there is another important clause which is relevant, my lord. Your lordship will kindly turn to 156. Subclause C of clause 15 at page 156. Subclause C, right at the bottom.
Signing and submission of the.
At subclause C there. The bidders will have to accept unconditionally the additional terms and conditions, instructions to bidder, service level agreement, etc. So the bid has to be unconditional. Now, what is it that he submits? is at page 124. Even the paragraph numberings have been changed, which means further additions have been made, but we ignored that. Our problem arose with clause 7, my lord, at page 127. Joint and several liabilities. All partners of consortium shall be liable jointly and severally. Next words have been added to the as mentioned proportionate clause number 4 during the pre-qualification bidding process, etc. Rest is fine. Rest is identical with the format. But these were
all partners of the consortium shall be liable jointly and severally.
up to that extent, it is all right. Next few words, next 7 or 8 words have been added.
As mentioned, proportionate, clause number 4.
Clause number 4. Now, if your lordship goes to the in the format, this portion is not there. He adds it, they add it, and if your lordship will go to the top of the page, those 7 words do not find place in the format. Now, if your lordship comes back to page 127, the one that they submitted, if your lordship goes to the top of the page, although it is the main clause is numbered as clause 6, just below that, your lordship will kindly see the sub clauses. Page 127. Although the main clause is 6, the sub clauses are marked as 4.1, 4.2, and 4.3. And if we read this 7 jointly with this proportionate share, which means you are not taking full responsibility for the contract.
Only up to this extent.
Only up to this extent. And now what happens is we ask for a clarification. Please clarify. They resubmitted this document. They resubmitted the same document.
This under, which same document?
This same agreement.
Okay.
Now, our problem.
They have changed that.
No, they have not changed. Those 7 words still remain.
Oh, achha.
So what happens is.
So they have changed this percentage, or what they have changed?
Nothing, Malak. They have resubmitted the same document.
Document you mean is this agreement?
Agreement. So now your lordship will kindly note.
Where is the changed agreement?
There is no change in agreement. There is no change there. Now, we are not.
First, they have submitted this page number 127 document this.
Yes.
And then when you sought clarification, again they submitted the same. Where is that again one document?
That is neither have they annexed. We also didn't bother because it is the same one and the same document.
And this.
In fact, they submitted some kind of a working capital certificate or something.
Joint and several liabilities is clause number 5 in the performa. Working capital is 6. Here they have changed it to 7 and 8. How it is?
Exactly, Malu. Which means they have changed the entire format.
Changes, how this numbers, the paragraph numbers are changed.
40 but 70.
Here in this clause 1 is for example, my lord, at page 188, lead partner clauses clause 2. In their page 126, the lead partner clause is clause 4. I, Now, how we are to examine the tenders for responsiveness is at page 168, clause 22. If we read clause 7 of page 127 along with that 4.1, firstly, it becomes a conditional bid. And secondly, clause 22, examination of bids and determination of responsiveness. A substantially responsive bid is one which conforms to all the terms, conditions, and specifications of the bid documents without material deviation or reservation. Material deviation or reservation is one. We are concerned with B, which limits in any substantial way inconsistent with the bidding documents, the employer's rights or the bidder's obligations under the contract. So the moment we read 7 with that 4.1, it limits in a substantial way inconsistent with the bidding documents, the employer's rights or the bidder's obligation. So therefore, my lord, and here is a case, my lord, if your lordships will have a look at the manner in which the tender committee undertook the decision-making process, which is in the second volume of this, my lord.
Yes, Mr.
Lordship, if Lordship is hearing for final disposal, then I'll have to place the complete case because, yes, now, Lordship will kindly come to page 153. Let us come. I'll have all the judgments and everything I'll place. Yes. Now, my learned friend started with the notes at page 153. 153. The documents to be furnished by the bidder to prove that he is satisfying the eligibility criteria. Lordship will kindly mark this word. Eligibility criteria laid down should all be in the bidder's name. This is what they relied, except in cases where, though the name has changed, owners continue to remain the same, and in cases amalgamation of entities when a holding company relies on the credentials of its wholly owned subsidiaries. Please refer to clause 2 of additional terms and conditions of GM bid document. This is very important. What is clause 2 now? Page 140. Two point two.
Yeah.
Joint venture consortium. 2 or 3 companies, contractors may jointly undertake contracts Each entity will be jointly and severally responsible for completing the task as per the contract. Name of all the members, etc. Lead partner 50%, members 20. Joint venture consortium must comply the following requirements. The joint venture must enroll in the name of lead partner, that we have done. 2, the qualifying criteria, parameters, example, which is not, everything is not included. For example, experience, financial resources, etc., and the equipment fleet strength of the individual members of the JV will be added together. And the total criteria should not be less than as spelled out in the qualifying eligibility criteria as specified in additional terms and conditions. However, the required working capital shall be made by individual members of JV consortium as spelled out in the relevant clauses. So individuals are allowed to give. A joint venture we have formed, till now, this joint venture has not worked in any projects. How can he procure a local content certificate of the name in the name of the JV?
How again, how you have procured it on 17/8?
That is a illegal thing. They asked and we have done it. I made this submission. In fact, this submission should not.
Suppose tomorrow we admit, yes, okay, no problem. You have.
In fact, that exercise,
Just a minute.
that exercise is not.
Just a second, please. Try to, please, what we are thinking, suppose we held that yes, even though he has submitted the certificate on a later date, now you yourself are saying this certificate is illegal. So even though if it is admitted that you have submitted, and it should be taken
Actually,
into
they should not have
consideration.
asked it. They should not have asked it, Lordship.
What contrary?
So they should not have asked it. Now, what we have to do for all experiences, individual, if Lordship is over with my hearing, then I can close it.
Yeah.
If it is. Or,
Sir, how can I say?
Yes.
You are free to argue.
Yes.
You argue whatever you want, sir.
Now,
You consider it all these things.
now, this particular criteria, so for a joint venture to become eligible, individual experiences, resources are to be submitted.
So you're, even though if you have submitted these two.
Which fulfills the requirement.
It pertains to JVWB or this Ambe.
Yes.
That has to be, that is sufficient, that is meeting the criteria, and
Yes.
therefore that is sufficient requirement, and they were not supposed to ask for that further certificate, and even though if they have asked, you have produced it.
We have produced it, but they should not have asked it.
They should not have asked it, there is no requirement, because looking to this condition, this full.
Yes, that is why here what they have said, that strength of all the individual member JVs will be added together. So they have to do that calculation. And what we have done later on, we have not changed the datas, the credentials. The certificate.
One more name is added in that certificate.
Not only one name.
3 names.
3 names were added, and it has been reduced from 100% and 50% to 50% because the average was found out. So there is no consideration of any other local content in respect of any of the companies. Whatever was there in the first 2 certificates, that has been divided amongst the 3.
So as per your contention that you have already fulfilled the requirement of the tender conditions of furnishing this
2 certificates.
2 certificates, and that is sufficient. They have not asked, they were not supposed to ask for further this certification, but even though if they have asked, you produced it.
We produced it. Now, the formation of the joint have changed, that is 4. The bid, and in case of successful bid, the agreement shall be signed so as to legally bind all members jointly and severally, and any bid shall be submitted with a copy of the joint venture consortium, providing that the joint and several liabilities with respect to the contract. So if the successful joint venture is there, then they have to execute a fresh joint venture agreement.
After award of the contract.
Yes. They have to execute a fresh one. Next page.
Yes.
Clause 6. The bid submission must include documentary evidence of the relationship between the JV consortium members in the form of JV consortium agreement to legally bind all members jointly and severally. For the proposed agreement, which should set out the principles of the constitution's operations responsibilities regarding work and financial arrangement, participation, percentage share in total, that percentage they have asked. So when we say 50, 20, 30, there is no deviation.
In relation
And
to
liabilities,
liabilities.
jointly and several. So in clause 4, we have said very clearly that jointly and severally we have to be liable. So they are not prejudiced in any manner by adding of those 7 words. Clause 4, clause 6, clause 7. If we read them conjointly, if you read them individually, makes the same meaning. In respect of each and all the firms of the joint consortium. In respect of each and all the firms. That means individual again, it has come down. Such JV consortium agreement must evidence the commitment of the parties to the bid for the facilities applied for, if pre-qualified, and to execute the contract for the facilities if the bid is successful. So I have to execute a fresh bid, consortium agreement.
Yes.
On hyper technicalities, they are right in cancelling me. But if we look at the intent, now, page 144. Roman 5, last one. In case the bidder is a joint venture consortium, the work experience of any 1, 2, or 3 of the individual members of the JV consortium itself may be furnished as work experience of the bidder. The local content will definitely come under joint work experience. Page 144, last part.
Clause 7.
Clause 7. In case the bidder is a joint venture consortium, the work experience of any one. What is this work experience all about, Lordship? In my humble submission, the work they have executed where they have utilized local content products. So here they themselves have said, there may be ambiguity in the NIT and the terms and conditions. And for that also they have a leeway. Clause 22, I'll come a little bit later. So in case the bidder is a joint venture consortium, the work experience of any 1, 2, or 3, they allow 3 partners maximum.
Yes.
Of the individual members of joint venture consortium, the itself may be furnished as work experience of the bidder. Page 146. The work experience certificate issued by employer, principal employer applicable should contain the following important parameters, information furnished in the bidders. So the work experience certificate, including this, although with the basis of these materials, I have to procure it from the chartered accountant or cost accountant. But cost accountant on its own, they cannot issue that certificate. They must look into some past work which I have executed. We have to see the sequence of events. All of a sudden, this certificate cannot be issued by these competent authorities as
Where is that clause which says it will add the experiences? Page
page 140, 140.
14?
Roman 2, 2.2, Roman 2.
So when they ask for ask from you to seek this clarification, that submit this joint certificate of in the name of all the three, whether you have protested.
We have noticed that is why initially why we have given individual certificates. By going through these records,
Nee, you can very well ask them.
and the problem is that it is a GM portal, Lordship. There is no scope for communication. Under GM portal,
You can, you are free to approach this court. That what they are asking for it, sir, it is not required at all.
it is
In fact, whatever they have asked for.
whatever they have.
You have submitted the certificate also. That is of 17/8/2024. When they ask you, you have submitted that.
We have submitted it because they asked us and we have consulted and we have not changed any of the data.
Mr. Sekia, now,
Now,
just a minute. Now you are arguing that they should not have asked it, or there is no question of or there is no justification in asking that. You can raise that then and there.
Lordship, it is like the bargaining power with them, with us, comparing, we are just a bidder, and that is a state. What they have asked, they have asked us that it should be in joint name. Have we changed the required, that 50% requirement? Have we added any other additional quantity of local content? They asked it in the name of JV. JV till date has not done any work of its own, which is known to them. The joint venture certificate, the last date was 5th of August, and the consortium agreement was executed on 2nd of August, 3 days earlier. We are bidders, Lordship. We are not that expert. The technical committee or the tender committee, these are the expert people.
If you argue this, these are the expert people, then why should we interfere?
No,
in
these
their
are,
expert
that is why they are asking a document which is not required under the terms and conditions of the thing. So even if you don't go to that stage, at the very first part, Lordship, because we have challenged every action, not only the last action. We have started challenging, we challenge. What are our prayers, Lordship? Let us see that. In the writ petition, we all 3 stages we have challenged. So when they have given us this 22nd rejection order of 22nd August, we have challenged it. The communication 28/8 and another 2 of 22/8. So we came to the earliest possible time. Until now, it has not been finalized. The tender has not been finalized till date. And it's a 10 years contract.
Yes.
So now coming to page 146. The work experience certificate issued by employer, have lots about it, 146, the top line.
Yes.
The work experience certificate issued by employer, principal employer as applicable should contain the following important parameters in line with the information furnished by the bidder in BSc, the various works, work experience, etc., etc. Now coming to note, lot of reference and stress has been given on the notes. Now what the note says, for eligibility, total amount of work experience, adding all the experiences value. That value, what is this value? The work experience value, what is the quantum of that work, including the local content, that 50%, 100%, these are quantities. For eligibility, total amount of the work experience, adding all the experience value during the consecutive 365 days declared by in BSc should be at least 50% of the annualized value or estimated value, whichever is less. B, in case of joint venture consortium, above documents of partner within bracket S shall be submitted and work experience shall be made collectively by all the partners members. very clear, Lordship, in my humble submission, that individual certificate are acceptable, which we have done. (149). Supporting documents to be uploaded. For first paragraph, scan copies of PAN, etc. So all these are individual, GST individual, then note, Lordship, will come down below. In case the work service is awarded to a joint venture consortium participating in the tender, they have to submit PAN GST registration as applicable in the tender in the name of the JV consortium after award of work and service at the time of execution of agreement before the payment of first running on account of bills. So there is scope that if I am successful as a joint venture, then I have to do a lot of things, which are subsequent events.
Yes.
Page 150. Legal status of the bidder. The bidder should be individual proprietorship firm, company registered under Companies Act, joint venture consortium. So when they say that everything should be in the bidder's name in terms of that second page, which my learned friend showed, that is not a part of eligibility criteria, page 132. Procedural can look at, because their main reliance upon this sentence. The tender document starts at 131, the next page. Scope of work, bill of quantity. They are referring to this. This is not a part of eligibility criteria. The tenders are invited online from the website so-and-so from eligible bidders. The registration should be in the name of the bidder for individual, partnership firm, partnership, proprietorship firm, partnership firm, company registered under Companies Act. Whereas for participation of joint venture consortium through GEM portal, everything is done through this, Lordship now. The registration bidder should be in the name of the lead partner of the joint venture consortium, and the submitted documents against eligibility criteria should be in the name of joint venture consortium. This is what they have referred. Now, if we look at this, and I have just shown all the criteria, including eligibility criteria, eligible bidder, everywhere there is a conflict. And there is no scope, we have to challenge it, because if we look at the page 140, the eligible bidders, where individual certificates are acceptable, they will do the adding part. Eligibility criteria, clause 3 at page 140, eligibility criteria for bidders, there also everything is permissible. That particular sentence from scope of work, bill of quantity cannot be included as a part of eligibility criteria. This is beyond the criteria laid down under the NIT terms and conditions to be eligible criteria. And when they say that it should be in the name of bidder, if it is a joint venture also, that New Horizon and everybody has, all the judgments have very nicely clarified. So I have page 150, the legal status of bidder.
To say that everywhere they have mentioned that
Individual.
Individual and the work experience of the partners, everything is to be taken into consideration, the financial capability and everything has to be taken into consideration jointly. So this certificate which you have given regarding the local content of two of the partners of our members of the joint venture, that is
sufficient.
That is sufficient.
Because it fulfills the 50% requirement.
Fine.
Page 152.
Now, what about this another argument of this change in the performer?
Change in the performer, Lordship. Now, before going there, let us see what is there in evaluation of tender, which we have elaborately argued and placed also. Now coming to page 168, examination of bids and determination of responsiveness.
Yes.
22.1. This particular clause has totally ignored by the learned single judge in my humble submission. And this was my main plank. Page 168.
8. Yes.
Examination of bids and determination of responsiveness. A substantially responsive bid is one which conforms to all the terms, conditions, and specifications of the bidding document without material deviation or reservation. So, a substantially responsive bid is one which conforms to all the terms, conditions, and specifications of the bidding document without material deviation or reservation. A material deviation or reservation is one, they have defined it, which affects in any substantial way the scope, quality, or performance of the works.
This is not the case.
This is not their case, but my case is here, Lordship, that adding 7 words, will it affect the work? Is it a material deviation? Is it amounts to non-responsiveness of my bid?
To some extent. To some extent. Because here you have added these 7 words.
The 7 words, what does it signify? What
signifies-
actually what they want?
It limits the liability of the each member of the joint.
Lordship will kindly come to 4. If they are reading absolutely the same clause, let us come there.
Yes.
Page 124. Page 127, Lordship. All partners of consortium shall be liable jointly and severally to, as mentioned in the proportionate clause number 4. Now, what is clause number 4, Lordship? Will kindly see the previous page. Clause number 4 is lead partner. Here, may I read it, Lordship?
Yeah.
JPW Infratech Private Limited shall be the lead partner of the consortium and in charge of performing the contract management, that is JPW Infratech Private Limited shall be the attorney of the parties duly authorized to incur liabilities and receive instructions for and on behalf of any or all partners of the consortium. That is one part. Then, and is the conjunctive here. And also all the partners of the consortium shall be jointly and severally liable during the bidding process and for the execution of the contract as per contract terms and employer. The second part is very clear that jointly and severally all are responsible. And when this is read with clause number 7.
But why to create a confusion?
I could not clear it. Absolutely.
When these they have specifically said, give this.
That is the next catch.
This again, who has mentioned in proportionate clause number 4? What is the need of that, sir? Why do you give this?
Lordship, whatever is done is done. I am arguing on that.
This gives
That smart advocate must have.
In case any time if there is dispute arose, you say, yeah, we have already mentioned, sir.
Yes,
that
now
this liability is up to this.
Yes,
only.
Lordship, that is why
That
they
may or may not be accepted that argument, but it is there, sir.
Yes, Lordship, I'm coming to that. I'll address Lordship's query also. But if we read this, what they want.
This is what the contradiction. That once you are saying we are completely liable, and in one para you are saying up to this extent we are liable.
Where, Lordship?
These one.
As per 4.
All partner of consortium shall be liable jointly and severally to, as the mentioned proportionate clause number 4. Where is the need of mentioning
That
this?
proportionate 4 is again
50%, 30%.
No, that is not 4. That is 6. That is 6, Lordship will kindly say on top. That is 6.
4, sir. Sir, that is not 6, that is 4.
No, that is
After
6.
having changed
That is 6.
4.1.
No, that is 6. In our agreement is 6. Lordship will kindly 127, the top participation share and work responsibility. That is 6. After that, it is
Sir, if you are referring to this lead partner 4, page number 126.
Yes.
Sir, here where is 4.2?
There is no 4.2.
So when you why you have mentioned is this in clause
We have not mentioned about 4.2. We have only mentioned clause number 4. 04. 04. And 04 is previous page. I am not limiting it. After N.
It's proportional of time. Or proportional of time. আমাদের বলে মানুষ এডমিটে পড়ে না সেখানে পড়ে মালক মোর ওয়ান টাইম লেভেল এই ওয়ান টাইম লেভেল খালি আমার 10 দিন হলো আজি হলে মাথা ঠিক হবে আমি মাল করব তোমাদের রেফার লেভেল সুপ্রিম কোর্টে মাল করব
But this is then, this come to page number 27.
127.
The participation, share and work responsibilities.
That is top. They have no this.
Just the top. Here, it starts 4.1, 4.2, 4.3. Why? Where is the question of giving this four numbers here? Start from 4.
That lordship, it has nothing to do with this four.
That's why a confusion was created. That's why a confusion was created, sir. You are referring to which 4?
Now, yes, Lord.
You are referring to this earlier page 4 or?
I fully agree. Lordship, that
When there is a
if-
confusion, then certainly.
then when it is said clause 04, there is no confusion about that. If you read clause 7, no,
Here also
Lordship,
only
here, now
you have
the
referred only 4. It is not 04 if we go by all this.
it is 04.
Then it
In
is
clause
not
number
04,
7, it is 04. नहीं लॉर्डशिप देखिए ना
Confusion really?
क्लॉज 7 पे आप देखिए द सेकंड लाइन 04 क्लॉज नंबर 04
Sir, 04, where is 04?
04 is we have to go to the previous page. So that is why there's a confusion, but my submission is yes, there is a confusion. I cannot shirk away from that situation.
In
They-
that
in that
situation,
case-
when there is a confusion, if they have rejected that, it's a.
Yes,
very
now lordship will kindly
Yes,
come to
sir.
lordship will kindly come to page 278.
278.
Yes.
Yes.
Here, this is the request from their side.
Yes.
Request number 1, they have elaborated. Request number 2, they have elaborated. Request number 3, due to text limit of the by the GEM portal, the query is attached. There is no query, and if you look at lordship will kindly come for a moment at 283 page number. This is our rejection, serial number 3. JW Infradeck, disqualified, status is disqualified. This
Yes.
yes, so serial number 3, disqualified. After that, there is a button called view. So if you press that view, then we go to the details. Now, if lordship is pleased to come to 278,
Yes.
due to text limit by the GEM portal, the query is attached. There is no view button, we could not look at it. In our affidavit, in our petition, that is,
Even though if you were able to look at it, this remains the same.
this remains the same. Now, what, we have to go to the minutes now.
Even though if you-
Now, we have to go to the minutes. Now, when they are seeking clarification, because I'll have placed the minutes. The minutes. Page 57 in the second. Page 577.
Second volume. Now we'll, time is over.
Tomorrow or but status quo has to be maintained. That is my submission.
Yes, at least.
Then lordship may dismiss it because if the third party writes,
Sir, dismiss it without even.
that is
considering
my
the
50% also is not there. Then therefore the
Tomorrow?
status quo.
Tomorrow?
Tomorrow or open, whatever, because I'll have to elaborate the whole argument.
Then whatever.
It
Then on the, start on the, just after the hearing there, on 3rd. the motion.
Third day, I have no difficulty, Lordship, but till then status quo.
Sir, please, if we are not totally convinced, then we are not going to pass any order. Otherwise, we would have simply.
No, suppose, Lordship,
Simply
tomorrow
because
I am
we are
succeed in the
not-
appeal. Suppose I succeed in the appeal, then what? But this is a 10 years, it's not a public project that the work will suffer. It 1 year time they are taking for,
Mr. Segia, please.
Lordship will
Because,
kindly
sir,
see here, 1 second, Lordship.
You know, sir, where we find without even asking, we are passing a stay order. If we are not convinced, then certainly, sir, please don't insist. Where we are, even though we pass the orders, stay orders without hearing the parties. If we are convinced, then please. That is.
Then one observation subject to final outcome of the litigation.
Sure.
That observation.
Your Lordship is fixing it on third one. Your Lordship is fixing it on third.
Subject to outcome whenever, yes, Mr. Sekia.
Let it be on third. I'll be doing it. Third or fourth. Let it be on fourth, Lordship.
No, fourth.
No, that lot of cases were fixed, Lordship.
Let it be third, my lord.
Let it be on
Because
third.
my friend will take at least 1 hour more, I think.
My friend is happy there's another day. He was asking me why there is not another day.
Listed on third of January, 2024, 2025. The final result of the, and then the final outcome of the tender process in question would remain subject to the decision of this written.
Highly obliged, Lordship.